more savory. And he said, what do you?
Now in session, presiding the Honorable Seema G. Patel. All persons having business herein are here with attention, and they shall be heard. God save the United States, state of Michigan, and sign.
Morning, welcome back. Please everyone be seated. Call the case. This is case number 24-11, Northland Family Planning Center versus AG Dana Nessel et al. We are back for another day of trial. I think we left off with Dr. Wubenhorst's cross-examination. At this time, are there any preliminary matters before we resume with the cross-examination?
Not for the plaintiff, Your Honor. Plaintiffs.
Should we do appearances?
Yes, we should do appearances.
Good morning, Your Honor. Megan Kelly for the plaintiffs.
Paul Dwayne, plaintiffs. Hillary Schneller.
Morning, Your Honor. Alexandra Willingham for the plaintiffs.
Good morning, Your Honor. Allison Epperson for the plaintiffs.
Good morning, Your Honor. Rachel Miller for the plaintiffs.
Good morning, Deja Tillman for the plaintiffs.
Good morning, Your Honor. Kendall S. Benson, Assistant Attorney General for the intervening defendants.
Good morning, John L.A. Tuttle, Assistant Attorney General for the intervening.
Good morning, Christopher Braverman, Assistant Attorney General on behalf of Director Marlon Brown.
Good morning, Assistant Attorney General Rebecca Abuna on behalf of AG Nessel.
Neil Chivinandi on behalf of AG Nessel.
Morning, Brianna Listerman here on behalf of AG Nessel.
Assistant Attorney General Daniel Ping appearing on behalf of defendant Elizabeth Hertel.
Thank you very much. Now, with the appearances on the record, are there any other preliminary matters before we recall the witness?
Your Honor, just one clerical thing. I was reviewing all of the exhibits and the plaintiffs filed J8 and J9 on our behalf. I just wanted to note in your notebook, they are J6 and J7. So there's just, the exhibits are exactly the same, just the number that's on your notebook is different. I don't believe those were specifically referenced. But I just don't want, when we're submitting closing arguments on the briefs, I don't want there to be any confusion. So I just wanted to put on the record, the exhibits are exactly identical. It's just the numbering got off. So.
Okay, thank you for that clarification. I appreciate it. Okay, anything else? With that, we'd like to recall the witness, Dr. Wubenhorst. Good morning.
Good morning, Dr. Wubenhorst.
Is that on? Is the
Absolutely working. That's check.
Does the red mean that it's on or does? Sorry, thank you. No.
Can you hear me now? Okay,
Morning, Dr. Wubenhorst.
good morning.
Since leaving the stand yesterday afternoon, have you talked to Mr. Benson, Mr. Tuttle, or any of the other attorneys about the substance of your testimony?
Yes.
Now, you testified yesterday that you
Well,
don't
I'm sorry, can you clarify? What do you mean by the substance of my testimony?
just about anything that you're going to testify to here today.
Just related to the case, yes.
Now, you testified yesterday that you don't hold any current positions in North Carolina that are listed on your CV.
No,
But you talked to Mr. Benson about how you review medical licenses for the state of North Carolina.
yes,
Now, you are not a member of the review panel for the North Carolina Medical Board. Those positions are appointed by the governor.
that's correct.
So you're a medical reviewer for the board for malpractice actions and that sort of thing.
It could be malpractice, it could be discipline, it could be, there are several reasons why.
All right, so I looked at their website last night. It appears that you get that position by emailing the board and indicating interest, and then there's some sort of review process, I take it, to interview for the job. Is that
Yes.
okay? Now, when you do work for the state of North Carolina, you charge them $175 per hour for time spent reviewing records and writing reports. Is that correct?
I don't remember how much it was.
Okay, that's what I saw on the website, so makes sense. Now,
Objection here, say.
okay,
Move to strike that testimony by opposing counsel. as it's.
All right, let me ask the question this way. Dr. Wubenhorst, do you recall how much you get paid by the North Carolina Medical Board for that work that you do?
No,
Okay. Does $175 sound about in the ballpark?
I couldn't say.
Now, I believe when we left off yesterday, we were about to look at Plaintiff's Exhibit 303. So can you turn to that in your binder in front of you? So this is an article you wrote in 2024 for Newsweek titled, "What's Really Behind the Maternal Mortality Crisis Facing Minority Women?" And the question that I posed to you was, it is your hope, as you write in this article, that abortion as a solution becomes unthinkable, for it has already done Black women, their children, and society immense harm. You believe that?
I would agree with that statement.
All right. And in writing this article, you relied on that same Reardon study that we looked at yesterday about deaths following abortion. I believe it's on page 3. There's a paragraph that says, despite the wide array of conditions.
Yes, I believe that was the study I was citing.
Dr. Wubenhorst, in your experience, doctors who perform abortion are degraded by performing abortions.
I would give a more nuanced response. My experience with colleagues who have been abortionists and who subsequently retire from the practice of abortion, have told me that they felt that that was their experience. This is something that I can speak to. And in addition, there is research to suggest that of the people who leave residency, OBGYN residency, planning to do abortions, most stop doing abortions within the first 5 years out of residency. So I think the nuance to that statement is that abortion, the performance of abortion has an impact on people who do it. And that's based on my own discussions with people who have come out of it.
May I approach? Yes. So we're in Plaintiff's Exhibit 55. This is in Binder 1. And I'm going to direct your attention to page 72, lines 4 to 6. Question: do you believe that doctors who perform abortions are degraded by performing those procedures? Answer: by my experience, yes. Now, Dr. Wubenhorst, you believe that physicians who perform abortions have committed murder.
I would say, and I know I have stated that they have considered committed murder, but that is not based on a legal definition of murder. Again, I don't understand all the fine distinctions between murder and homicide. I think to clarify that statement, what I was saying is that because I believe that a fetus is a human being, they have killed a human being. And whether that's homicide or murder, I'm not aware of the fine legal distinctions.
Can you please turn to Plaintiff's Exhibit 363 in that binder I just handed you? And refer to page 62, lines 21 to 23.
Hold on 1 second. I just need to get these others out of the way.
Oh, sorry. I know there are a lot of binders. So it's Exhibit 363, page 62.
I'm sorry, you said page 363?
May I approach? All right, so turn to page 62, lines 21 to 23. Question: and do you believe that physicians,
Your
oh,
Honor,
I'm sorry. Now, you testified at a trial in Indiana involving abortion restrictions. This is the trial transcript from that trial.
Yes,
Question, and do you believe
This
that
is improper impeachment. It's not actually impeaching.
it absolutely is? She says it's more nuanced, and her testimony while she was under oath in Indiana was a simple yes.
I'll allow it, please.
I don't see how that's a distinction.
I'm going to allow the cross-examination for impeachment purposes. If it's, you think that it isn't, I'll allow you to do redirect and clean up the test.
Question, and do you believe that physicians who perform abortions have committed murder? Answer, yes. Dr. Wubenhorst, you oppose abortion in cases of rape and incest.
yes,
You believe that all abortions are associated with harms to women.
yes,
You don't think there are any benefits to abortion.
no. I would like to clarify that I am referring to abortion strictly defined as intentional feticide.
Intentional feticide, yep. So to clarify, there are no benefits to abortion defined as intentional feticide.
Yes,
You don't believe abortion should be called healthcare at all.
that's correct. But as I have said a few times in this testimony, I understand that Michigan's law defines abortion as healthcare and states that abortion is a human right. So in preparing my expert witness and giving my expert witness report and giving my deposition, that was my understanding, because that is the law here in Michigan.
So for all of these reasons, this is why you believe that abortion is immoral.
For all of which reasons?
Well, we just went through a series of questions. You believe that physicians who have performed abortions have committed murder. You oppose abortion in cases of rape and incest. You don't believe that there are any benefits. There are only harms to women. For all of these reasons, that's why you believe abortion is immoral.
Yes, and again, I do want to clarify the statement about murder. When I made that statement, and I'm not backing off from the underlying idea, but I just want to make it clear that I don't know the legal distinctions between murder, homicide, manslaughter, and so on and so forth. But the answer to your question is yes.
You believe that abortion offends God.
I do.
And Dr. Wubenhorst, you believe that abortion should be illegal.
I think you just asked me that, and I said that abortion defined as intentional feticide is always wrong and should not be allowed. Yes.
Should be illegal.
Yes.
I'll pass the witness.
Okay. Thank you very much. Do we have any other questions by?
I think you do have a preliminary matter of the transcript and which testimony is going to remain. You've been provided.
Step up to the podium because I don't think that you can be picked up on the record otherwise. I'm sorry, and put your appearance again.
Yes, Christopher Braverman on behalf of Director Marlon Brown. Your Honor, when we closed yesterday, there was the open question of which portions of the transcript for Dr. Wubenhorst's testimony were going to be stricken based on the ruling on the New York Times article. We've just been provided a rough transcript from yesterday. I think if we had a few moments, we could at least confer among counsel to see if the parties would agree on which portions would be stricken. I think in terms of follow-up questions, that would be helpful in deciding whether there are any, or maybe it limits the amount of follow-up questions.
So I'm going to defer to Mr. Asmunson. What is your preference? Would you like to do your redirect of Dr. Wubenhorst right now? Would you like to take a break, go through this testimony, figure out what testimony needs to be struck and whether there is any follow-up questions from either of the parties or the other defendants, and then do your redirect?
I think I have reviewed the transcript and I'm prepared to take a brief recess to confer with opposing counsels. I think it's about 3 pages that we're talking about. I'm happy to chat with opposing counsel, see if we can work out an agreement, but I think that might just make things cleaner and more efficient.
Is that acceptable for the plaintiffs as well?
Absolutely, Your Honor. I don't think it should take very long.
Okay, sounds good. Thank you, Dr. Wubenhorst. We're gonna take a, will 15 minutes suffice? Okay, we'll say 15 minutes, and I will let my deputy let me know when everyone's back.
Very good.
Thank you.
Very much.
Thank you.
History Court claims is now in session.
Welcome back. You may be seated. Do we have a resolution to the striking the testimony?
So we have a partial resolution. The parties have conferred and are in agreement on a portion of the testimony that can be stricken from the transcript. And I can give you the page and line numbers if you would like.
And,
Please.
and just to be clear on the record, we still, for appellate purposes, we want to preserve any argument that we have that any of this should be excluded, but for the scope of what your order is, we are understanding what is going to be struck, and we're not opposing that in the scope of that order, but ultimately the order, we want to preserve our right to appeal that. Just
Understood. Thank you.
Okay, so the portion that the parties have agreed on begins at page 129, line 7, through page 131, line 7, and then starting again at page 132, line 6, through line 25 of 132.
Can you say that again one time for me?
All of it?
Yeah, 129, page 129, line 7 through 131, line 7,
Correct,
and then 132, line 6 through line 25.
correct.
Okay, thank you.
Okay. Now, on behalf of Director Brown, Your Honor, I am also asking the court to strike the portion beginning at page 125, line 2, up to the
Sorry,
first
say that again, page.
125,
Mhm.
line 2, up to the first portion that the parties have already stipulated to. And the reason for that is that it appears that the questions beginning at that point are all building the foundation for questions about the article that was excluded, because they are specifically focused on this concept of oversight of medical providers being frustrated by advocacy concerns. And without the article in the record now having been excluded, there is no other purpose or relevance for the questions leading up to the portion that the parties have agreed on.
Mr. Braverman, can I ask that you submit a written motion with that request? It doesn't have to be long, stating what you stated on the record, and then appending the pages that you are contesting. And then I can give intervening defendant and any party that wants to have a response to that, they can file a response, and then I can issue an order. So it's very clear what the record is that I'll be considering.
Sure. Do you have a request for how soon you would like that submitted?
I would request as soon as possible, but I have been, as you probably have figured out during the course of this trial, I tend to have things go pretty quickly. Would by end of day tomorrow be acceptable?
I will say yes, without knowing exactly how the rest of today's proceeding is going to go and whether we will be here tomorrow, but I will agree to that.
It could just be a one-page
yes.
motion with the pages attached, just so that I can see in front of me what I'm being asked to redact.
Yes,
and
I will agree
strike.
to that, Your Honor.
And then any response to that by Monday? Is 10 a.m. Well, actually, I'll be in a hearing on Monday, so end of day Monday for a
say
response?
Monday works, Your Honor.
Okay, and then I'll issue a ruling on that as soon as practicable afterwards.
Thank you. And I presume then that we can continue with Dr. Wubenhorst, and we will, for the purposes of this testimony, assume that the non-stipulated portions are at least still in the record and that testimony stands. Thank you.
Anything else preliminarily before we recall Dr. Wubenhorst?
Not for the plaintiffs, other than Mr. Braverman, please don't put out in the universe that we may be here tomorrow.
Retracted.
All right, thank you very much.
I concur with that sentiment.
Okay. All right, at this time, the court will recall Dr. Wubenhorst. I'm sorry, you have questions for her, correct? Okay,
Yes.
please, doctor. And doctor, you are still under oath.
Yes, thank you.
Good morning, Dr. Wubenhorst.
Good morning.
As you may have heard, I represent the Director of the Michigan Department of Licensing and Regulatory Affairs, Marlon Brown. I do not represent the plaintiffs nor the intervening defendants. We are a separate party as a named defendant in this litigation.
Do you mean medical licensure?
Well, the Department of Licensing and Regulatory Affairs is the agency that my client is the director of.
Okay,
And I will represent that includes all licensed medical providers
okay,
in the state of Michigan.
sure. Thank you for the clarification.
Sure. I just have a few questions for you today. I know you testified yesterday that you are not currently licensed to practice medicine in Michigan, correct?
That's correct.
Have you ever been licensed to practice medicine in Michigan?
No,
And you also testified that you did not review Michigan's licensing laws related to medical professionals. And you testified that that is something that is outside your area of expertise, correct?
yes, if I recall correctly, what I was saying is that that was not something I had opined on in the context of this particular case.
Right. The Michigan specific licensing provisions that may or may not be applicable in cases involving medical professionals.
Correct.
Now, is it correct that based on your involvement in North Carolina's review process that you've testified about this morning already, that in those North Carolina cases, there are licensed professionals involved in reviewing cases against members of that same profession?
I'm sorry, I got lost in your question. Can you repeat that?
Yeah,
please?
in the North Carolina cases that you have been involved in as a reviewer, is it correct then that cases against a medical doctor involve a review by other medical doctors?
So I think I understand what you're saying. So in North Carolina, the process is that, if I recall correctly, the complaint goes to the board. The board then assigns a physician for initial review. That physician then decides two things. Number one, whether there needs to be continuing review, and they ask for a specialist, for example, because I review OBGYN cases because I'm an OBGYN. So that's how the process works.
Okay, so in a case that has been brought against an OBGYN in North Carolina, you may be involved in reviewing the allegations and the evidence in that case.
Yes, after another physician has reviewed it. And I don't know the credentials or the specialty or specialty certification for the physician who does the initial review.
Okay. So generally then, do you think that it's good practice to have members of a profession involved in the review of cases that are brought against other members of that profession?
Okay, sorry, I got lost in your question. Are you asking me, do I think that when there is a case against, say, an OBGYN, that should be reviewed by an OBGYN? Is that what you're asking?
Yeah, my question was, is that good practice in your opinion?
Yes, I mean, I can't speak to whether that's how all states do it, but I'm not really the best person to think about that because I'm not operating or experienced at that level in terms of licensure.
Sure. And to be clear, I'm not asking you to opine on any other state's practices, but in your experience in North Carolina and limiting to that experience in North Carolina, would you agree it's good practice in those cases to have a member of the profession like yourself reviewing a case against another member of that profession?
I mean, I think that it's sort of a legal question, so I'm not sure I can answer it. As I operate within the regulatory structure of the state, so I'm not aware of, but when you talk about good practice, my experience with that is in the context of clinical care. So it's hard for me to speak about good practice outside of that context.
So you don't have an opinion on whether it's a good practice to have a member of the profession involved in the review of a case involving another member of that profession?
No, I think in terms of being involved in a case, yes. But I don't know, what I'm just saying is that I can't speak to whether there is some standard or some consideration as to what is good practice or best practice in this area, because I just don't have
Sure.
experience.
And to be clear, I'm not asking for any opinion beyond that of your own, whether you think it's a good idea to have that review in cases against members of a profession. I'm only asking for your opinion.
Yeah, I think it is, I guess what I would say is I think that it's helpful. And that's why they ask, when it's an OBGYN case, they ask me to review.
Thank you. Now, very briefly, the topic was raised yesterday about whether you were aware of instances where regulatory oversight of medical providers was frustrated by advocacy concerns. Do you recall that?
Yes.
Do you have any specific reason to believe that Michigan's regulatory agencies have been or may be unduly influenced by advocacy concerns?
I don't have any specific information at present. And I think the point that I was making was, I'm sorry, what I mean to say is I don't have any information to suggest that, excuse me, at the present time, that kind of interference is the word you're using, or the word you're, is influence.
Yes, the question was whether you had reason to believe that Michigan's agencies either have been or may be unduly influenced by advocacy concerns.
I think that I don't have reason to believe that that is something that is happening at present. And I think that the specific context that I was speaking of yesterday in terms of the opioid crisis was the way in which, just for clarity, the way in which advocacy efforts from both the patient advocacy side and pharma pushed physicians towards prescribing more narcotics, which led to the 3 waves of the opioid epidemic. The first wave being oral, second wave being heroin, third wave being fentanyl. I would need to review what exactly you're referring to in terms of impact on the regulatory agencies, because I think I was clear in saying that the regulatory agencies had to step in to address those issues because they were not being addressed by, we were not, as physicians, we were not policing that area ourselves and being aware that this was just a tsunami. Does that make sense?
That is helpful, Doctor. Thank you.
Yeah.
I don't have any other questions.
Very much. Do any of the other defendants have any questions for Dr. Wubenhorst? Okay, Mr. Asmunson, redirect.
Court's indulgence while I get situated here one moment.
Sure.
Dr. Wubenhorst, as an initial matter, can you talk about literature reviews? What do you mean? Are there various things that you mean when you talk about a literature review?
Yes, I think that there are different ways that you can look at a literature review. So on the one hand, when you are doing a literature review, there is the actual process of identifying articles where you turn on your computer, go to a database, and begin to search using specific search terms. Then the second phase of literature review is reviewing all of those articles. And so you can have, let's say, sitting down for, say, an hour and doing literature review, you might encounter 20 or 25 articles, which you would then download, review the methods, and so on and so forth. And then I think I mentioned the snowball technique, where you would go back, look at the literature that those papers cited. So there are different phases to it, one being the actual accessing the database and identifying articles of interest, and then downloading those and reviewing all of those articles and abstracting the information.
All right. Can you go ahead and turn to Plaintiff's Exhibit 231, and it's in binder number 2, volume 2.
I have one of three. And then I have this one, which is cross-examination documents, and then I have 3 of 3. This is 1 of 3?
Have a 2 of 3 for Dr. Wubenhorst. We used it yesterday.
Thank you very much.
Okay. So if you'll go to Exhibit 231.
Yes, I'm there.
All right. And at about line 10, you're talking about you have a master's degree in public health from Harvard. Do you
Which,
see that?
which page is this?
It is page 66.
Your Honor, I'm not sure. Not sure what Mr. Benson is doing with the transcript, but unless he's seeking to introduce or show that I somehow used impeachment improperly and didn't provide the appropriate context, you can't just point the witness to a transcript from the prior.
Your Honor, I would like to ask her to clarify what her testimony was. She was denied that opportunity yesterday. And I would like her to just review the testimony and ask what the context was in which she was testifying previously.
Okay, I'll allow it in that context.
So if you can go ahead and take a look at lines, and I don't need you to read them into the record, just to refresh your recollection of the context in which you were asked about literature reviews during the Texas case. So start at line 10 and go through line 21.
Yes.
What were you testifying about in that context?
In that context, what I was testifying about was the number of the literature reviews that I had done for that case.
Well, let's talk about literature reviews generally. I know that we talked about literature reviews that were conducted by different organizations in the past, where let's see, what were some of the organizations? I think the APA was one of them.
Mm-hmm.
American Academies of Science. Those are
National Academies of Science.
National
Mhm.
Academy of Science.
Mhm.
Those are referred to as literature reviews. Is that correct?
So I think the National Academies of Science would be called a systematic evidence review, but it is a review of the literature, yes.
Okay.
Mhm.
And when you're reviewing literature, how many pieces of literature do you review?
So typically for the situations, there are sort of 5 general, excuse me. There are 5 general situations where I'm reviewing literature. The first is for our journal articles that I'm writing myself. And typically when I review for journal articles that I'm writing for myself, I will review anywhere from 30 to 70 papers. And the specific time that I'm accessing the internet and looking at those, I don't, it's really hard to quantify that because I do those multiple times a day. So for example, for the 20 articles that I've actually written, you multiply that by 30 to 70. That's quite a few articles and reviews that were done. The second context is that if I'm asked to opine in a specific case, and in the case of Texas, for example, this Texas dismemberment case, if I'm recalling correctly, I reviewed 117. I'm sorry, reviewed 117 articles. I don't remember exactly how many of those I cited. And so in that context, I had done these literature reviews in order to identify those articles to support my opinion here. And it's similar for each expert witness case that I've done. I have, as I've said, typically review anywhere 30, 75, and this was a lot more, 117. For the Inter-American Court, I think I probably reviewed about 120 to 130 articles.
And so when you're talking about those numbers, you're talking about the total articles that you looked at. That's
Yes.
so you have reviewed thousands of articles over the course of your career, I would assume.
Yeah,
Is that correct?
definitely, definitely.
Now, individual literature review, well, not talking about individual studies that you have reviewed and so forth. Would it be accurate that that there's been more than 100 times that you have sat down and looked at articles?
Objection leading.
I can rephrase the question. How many different times have you sat down to review those thousands of documents?
Well, if you think about it, like I was saying, for this case, which, as I said, I remember distinctly how many articles I reviewed, in order to extract those cases, I had to literally sit in front of the computer many times, because it's not just that you sit down and you immediately see an article. You're sifting through a lot of articles that have the same search terms in them, but you have to sift through them to find ones that are relevant to the question that you're trying to answer in your literature review. So you could sit down in front of the computer and identify 3 or 5 articles, look at those articles, go back a few hours later, and I have specific times when I try to do that, identify those articles, but it's just a constant process. I don't really think in terms of, oh, I'm counting how many times I do this. So.
And for sitting down to do that process, you have sat down and done that process numerous times. Is that correct?
Yes.
And throughout your career, would it be true that you've done that process more than 100 times?
Yes, because when I really, when I got back, especially when I did my postdoctoral fellowship, which was heavily focused on research, I did very intensive data analysis and literature review to support the articles that I wrote during my fellowship.
Okay.
Does that?
I think that makes sense.
Okay.
And if you were asked previously, approximately how many times have you done literature reviews throughout your career, referring to that process of sitting down and doing one, not necessarily the individual documents that you looked at, it would be more than 100. Is that correct?
Yes. I mean, on average, I would say in a typical week when I'm either writing an article, doing a journal article, writing for, say, policy brief or something like that, I will usually sit down for a couple of days a week doing literature reviews.
Now, you are pro-life, is that correct?
Yes, sir.
In drafting your report and providing your opinions today and yesterday, are you able to operate in a neutral way in giving your testimony to this court?
Yes. And I think that that's important because in Michigan, the law is very clear that about reproductive freedom and right to abortion.
And are you here to change any of those rights?
No.
Through your report, are you advocating any change to Michigan's constitution?
No.
Let's talk about a couple of different studies. You can take that small binder in front of you. Cross-examination documents.
This is the one right here.
Yes, that one. Now, please turn to Exhibit 235. This is deaths associated with pregnancy outcome. You see that?
Yes.
David Reardon was the author of this study.
That is correct.
Has this study been retracted?
Not to my knowledge.
Did you review the methodology? Well, how do you review studies? Can you just give us a description of that?
Sure. So I'll read the study. I'll go through the materials and methods. If I'm able to, well, sometimes studies will not go into detail about their methodology because they've done that in a previous paper. So when that happens, you have to go and pull the previous paper so that you can see what methods were used. And then I will look at the methods to see if the methods are appropriate to the question being asked and if the study design was aligned with the question that was being asked. Then I will try to do reanalysis of the data to not a reanalysis, but I'll look at the analysis to see if statistically it makes sense. Look at the data, look at the results, look at the discussion to see if the discussion is consistent with the results that were found and the limitations of the study as well as the conclusions.
Okay. And you
then
did
also, I'm sorry.
and you did, go ahead.
And then also, as I said, I will look at the studies that this study relied on and pull those and take a look at those.
What were some of the studies that this study relied on?
Well, one of the studies was the study by Mika Gisler and colleagues in Finland that looked at pregnancy related mortality. And this was kind of one of the first studies where the Scandinavian databases kind of came onto the scene as a way of looking at outcomes, as a way of looking at particular problems where you could study those outcomes in context because their databases, as I think I said yesterday, collect data from the time a person enters the system at birth until death. And so you have access to all of those data, which is very powerful. It's tremendously powerful. And it's able to answer questions that it's very difficult to answer using the databases we have here in the United States.
Okay. You were asked questions about another, I guess, did you have any concerns with how this study was conducted?
No, I think I've actually worked with this study used data from Medi-Cal, which is the California Medicaid database. And I actually have worked with those databases, not in California, but one of the studies, some of the research I did during my fellowship looked at, I think it was, we were trying to look at maternal mortality. And to do that, you need a lot of power. You need to have, because maternal mortality is a rare outcome. And so we were using Medicaid data across different states. I don't remember exactly which states right now. So I'm familiar with the limitations of those data. But within those limitations, I think this study actually was conducted pretty well.
If you turn to Exhibit 249.
Yes.
This is another study by David Reardon. What is an open access original article?
So open access journals have come on the scene, I would say, within the last 7 to 10 years, because they don't require a subscription to access. Most journals have to cover the cost of their reviewer time and, paying for if there's a print edition, but they recover those costs by charging subscription fees. But it's sort of inverted with open access journals because what they do is you actually pay those fees and then they publish your journal and then it's widely available. And so it's really been very interesting that, for example, ACOG is going to be having, I believe, an open access journal pretty quickly. PLOS, which I mentioned yesterday, has an open access journal. So this is a new way. I don't know if there are business reasons behind it, but it's a different model for a publication.
And as someone who's doing literature reviews, do you still have to scrutinize those articles?
I scrutinize them the same way I would any other article. There are good articles in open access And there are articles that are not so good. It's the same with any of the peer-reviewed literature. There are some articles that are not well designed, not well analyzed in the peer-reviewed literature that you have that's behind a paywall. And this is actually one of the when you're dealing with literature reviews, is that you have to deal with paywalls. And what you know what I mean? I mean, you have to have access either through an academic database or you have to pay to get the article.
And is it true that most journals at some point have to retract articles?
Yes.
Objection reading.
I can reformulate the question if you'd like. How are journals affected by retractions?
Well, retractions are actually a fact of life in academia. And there's actually an entire website called Retraction Watch, which monitors retractions in the biomedical literature. In addition to that, there are web crawlers. Web crawlers are it's a kind of software that goes over the entire internet within a certain period of time, like 48 hours, that look for retracted articles. And so it's kind of a fact of life that articles can be retracted, and not always because there was necessarily research misconduct or anything else, but generally because journals may say, okay, you need to reanalyze your data, or there's some questions about this. And retractions happen and they are a fact.
So for what purpose did you rely on this study by David Reardon, the one that is at 249?
So one of the provisions of the Michigan law regards coercion. So I was very interested in articles that are looking at coercion in circumstances where women are undergoing abortion. And so in this particular study, there was, they also were interested in this question, and that was why I relied on this study. It is a qualitative study that uses scales. In other words, it's surveying women and then assigning their responses along different scales for what the response is. And so it was helpful in terms of understanding what the impact is of coercion on women undergoing abortion.
And I'd like to shift gears and talk about Exhibit 239. You were shown a copy of this letter to the editor, is that correct?
Yes.
You were asked to read a portion in reply. And do you remember exactly what those words said, or can I refresh your recollection?
If you can refresh my recollection.
So it says, it's important to keep in mind that the study is registry based, not a randomized study with strict protocols and definitions. Thus, many of the complications are not really such, but rather concerns or adverse events that bring women back to the healthcare system. Such consultations result in diagnoses in the registries. These limitations are discussed in the article. Did you rely on all of the consultations, or I guess, what did you rely on from the study?
I relied on their hard data on specific outcomes and what those outcomes were: bleeding, infection, hemorrhage, and I'm sorry, let me clarify that a little bit. I was relying on, for example, with medication abortion, what the complications were in terms of bleeding, infection, need for further procedure for retained fetal parts and placenta, and then for surgical abortion, hard outcomes, what I would call hard outcomes, not consultations. And I think that it's very important to make that distinction, that what the authors are saying is that there's a difference between what they call consultations, which are where situations where a woman felt uncomfortable, she was having pain or whatever the specific issue was, and sought help, as opposed to complications that required medical intervention. And in fact, later on in the letter, they go on to say what their main contributions are. They said that their rate of serious real complications is rare, and that was between 2 and 7%, as high as 11%, and similar. And then it also says that if you go to the next page, the third bullet, it says bleeding associated with the medical method increases the likelihood that women will seek advice. And they go on to say in the last bullet, a high rate of complete abortion greater than 93% can be achieved with the medical method. But what that's saying is that 7% of pregnancies were not completed and needed further intervention, or could have gone on to be ongoing pregnancies in that particular circumstance. So I think that the authors wanted to make the clarification between the consultation, which might not have required medical intervention per se, and they do this in the article. It's very clear in the article, versus a complication such as hemorrhage, which required medical intervention, retained fetal parts and placenta, which requires medical intervention, or, for example, perforation.
And what's your understanding of the legal ability to have an abortion in these Scandinavian states that the study is based on?
Well, it's very interesting because I reviewed that not long ago, and unless the law has changed in the last 2 years, abortion is legal up to about, it's anywhere between 18 and 20 weeks. It varies between the Scandinavian states, but there are virtually no restrictions earlier in gestation.
I'd like to talk about Exhibit 107. Now, you were asked several questions about this exhibit. Do you remember exactly what portions of the exhibit were read to you?
If you could refresh my memory.
So if we go to page 5, it says here, in the highly politicized field of abortion care, opponents of abortion have promulgated the idea that the majority of women will opt to continue pregnancy once they view their ultrasound images. Have you represented that in any way, that the majority of women would opt to continue their pregnancy if they viewed images of their ultrasound?
No, I have not said that, and my review of the literature is inconsistent with that idea.
What does this study actually show?
I think what this study actually shows is that, and I think they outline this on the following page. No, hold on one second. Let me just. I think the study shows that when women see their ultrasound, the ultrasound of their baby, some will continue to choose their pregnancy, will choose to continue their pregnancy. And also that, and that's reflected in the slightly smaller number of women who viewed an ultrasound and then went on to carry their pregnancy. They make an important point in that patients with medium or low decision uncertainty, in other words, patients were decision certainty. In other words, patients who were uncertain about their decision were more likely to change their mind if they viewed the ultrasound. And that was approximately 7% of those patients. But I think the other point that is important, it's on page 6, is that as gestational age increases, women's likelihood of continuing their pregnancy increases as well. In other words, there's a linear relationship between advancing gestational age and women's decision to continue the pregnancy. And the authors say in the second paragraph on page 6 that this is consistent with findings that women's attachment to pregnancy is linearly associated with gestational age. And so, and they go on to say what I think is significant as well. The importance of gestational age for women deciding to continue the pregnancy suggests that it is the information the ultrasound scan renders, that is to say, gestational dating rather than the image. And so I think that that's the takeaway point that they are trying to make, which is a contribution to the literature.
I'd like to talk briefly about Exhibit 241. I think it's one of the next ones.
Okay, I have it.
And this is a study by Ann Moore. Why did you rely on this particular study?
I relied on this particular study because one of the questions is that one of the provisions of the law is involves screening for domestic violence and abuse. And as I've said, those are significant concerns, domestic violence, abuse, and coercion. And what this study documented was that there were a significant proportion of women who had experienced intimate partner violence, and also that there was coercion to have an abortion.
And is this something that ACOG has recognized?
Yes, ACOG has recognized this because what they have said in their guidelines for identifying coercion and abuse, that's not the title, I would have to see what the title is that the reproductive health encounter is a unique opportunity to screen women for abuse, coercion, and violence. And I would add to that trafficking, and to help them get out of it.
Now, you were shown a loose leaf exhibit. It was 236.
Just to assist Dr. Wubenhorst, I tucked them in the front pocket.
Oh,
of the
thank you.
binder.
Thank you.
Sorry.
Thank you for
Thanks,
doing that. Yeah. What's the title? of that?
236.
Yes.
What was the reason that you cited this article?
I cited this article to show that I was discussing the risks of surgical abortion, that surgical abortion is associated with an increased risk for subsequent preterm birth. And the authors state in the abstract that they refer to D&C, but the specific context of this was miscarriage and termination of pregnancy. And what they say, first of all, what they say in the abstract is that the increased risk in association with multiple D&Cs indicates a causal relationship. In other words, they are putting forward the proposition that there's a causal relationship between D&C and termination of pregnancy. And they are actually even more emphatic later on in the study in stating that they assess if you look on page 10 of 12, under the subsection interpretation of the findings and clinical implications, that paragraph begins, several systematic reviews assessing medium preterm birth and termination of pregnancy have reported an increased preterm birth rate in women with a previous miscarriage. And so they go on to say that they wanted to understand what was the association with D&C for termination of pregnancy. They further go down to say that intensified obstetric care should be considered in women with a history of D&C for miscarriage or termination of pregnancy. So I think that what this study is saying, and there's another study by author Saccone et al., which comes to very much the same conclusions, is that this is a risk, and this is a risk that women need to be made aware of. And that was the context of understanding what the immediate and long-term risks of surgical termination of pregnancy are.
Now, you've reviewed Exhibit 4, which is DHHS's materials that are required to be disclosed. Do you recall those materials?
Yes,
Are those all relevant to pregnancy?
yes.
One moment, Your Honor. I think I'm pretty much done. If I can just take a moment to double check. Dr. Wubenhorst,
Yes.
in formulating your opinions in this case, what did you rely on generally?
I relied on my understanding of the law, reading through the information provided by DHHS, my clinical experience, and my review of the literature.
And were you able to operate in an impartial manner in doing that?
Yes,
Objection leading.
How are you able to do that?
I was able to have a neutral position in evaluating this.
Yes.
I was able to have a neutral position in evaluating this because I recognized and understood and respected the fact that Michigan law says that abortion is a right and that abortion is healthcare. And so I worked within that framework to arrive at a neutral and impartial assessment of what the literature has to say about the relevant topics, as well as my clinical experience, which is by definition impartial.
No further questions, Your Honor.
Okay, thank you very much. Recross?
Just briefly, Dr. Wubenhorst, we were looking just now at Plaintiff's Exhibit 236.
Yes.
All right, can you turn back to page 10 there?
Yes.
Now, there's been testimony in this trial about different methods of terminating pregnancy, both for abortion and miscarriage. Use of suction is one, use of DNC, a sharp curette, is another. You understand that, yes?
Okay, let me just state it in the terms that I would understand it. So typically when you do a suction DNC, it's suction and sharp, because the curette not only does suction, but as you rotate it, it has a curetting action. If you're doing sharp curettage, which sometimes you have to resort to, especially in resource limited situations, or if the vacuum machine is not working, that is just with a curette, using that to remove retained fetal parts and placenta.
All right, Dr. Wubenhorst, let's look under interpretation of the findings and clinical implications that you were reading from earlier. You were reading from the first two paragraphs. The third paragraph states, another theory is that the curettage damages the endometrial lining, which may cause abnormal placentation in a subsequent pregnancy, thus increasing the risk of placental abruption, preeclampsia, placenta previa, and intrauterine growth restriction. Have I read that correctly?
Yes, and in fact, that is documented in several studies. But what's the question?
Just if I read that correctly.
Okay.
No further questions.
Okay, thank you very much. Dr. Wubenhorst, thank you very much. You may be excused. Your next witness.
We would like to call Dr. Curlin. We're going to need just a few minutes to set up the Zoom link with him.
Okay, let's take a short 10-minute recess. and confer with the IT department and make sure everything is up and up.
Thank you.
Thank you.
I'll recess.
Yeah. My highlighters keep disappearing.
I know, I'll miss you. Hello, thank you so much for the link.
So you're gonna do this share thing too?
Yes, though Megan wanted, I usually, actually, shall I join now and
Yes.
test it out, but then I'm going to drop off again?
Yeah, I would
And then
just
join
leave it.
again for
Yeah,
the-
I would just leave it.
Okay,
Yeah, he's in there right now. So
okay.
you both will be in there. And then when you're ready to share.
Oh, now I'm going to be the menace in the middle.
So you're in the Zoom webinar.
Just so it doesn't die on us mid, you know.
He's the person.
We have an entirely. I've been putting stuff on here.
Yes, everything is
You
on.
got your
Everything is
speaker
on.
off too?
Yes.
Okay, go ahead and do a share real quick. So you can share. Okay, she's good.
Okay, great.
Okay, yeah, she's
Excellent.
good. She's gonna unshare it now.
Go blue. Thank you.
Okay, are you guys good?
I love that.
Now in session.
Back, please be seated. Hey,
Morning, Your Honor.
good morning.
Assistant Attorney General John Fedinsky for the people. We'd like to call our next witness, Dr. Far Curlin, who's appearing remotely via Zoom by agreement. Morning, Dr. Curlin. Can you hear me all right?
I can. Can you hear me?
Yes, we hear and we see you just fine. Do you see us okay?
I do. I see the back of your head right now.
Well, all right. We'll see how the camera angles work, but I believe there's a swearing in process.
Yes, please.
Doctor, please raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Doctor, would you please state and spell your full name for the record?
My name is Far Andrews Curlin, FARRANDREWS
Great. And where exactly are you located? Where are you joining us from?
I'm in my office in the Trent Center for Bioethics, Humanities, and History of Medicine at Duke University.
And that's in what state?
North Carolina.
Great. Well, thank you for joining us, Doctor. You might hear an objection at some point. If you do, please pause your answer. If there's any lag in the technology or difficulty hearing my voice or the court's voice or plaintiff's counsel's or anyone's counsel's voice, please just let us know, okay?
I will.
And at some point, we might share a screen and show you some documents. If you have any trouble seeing anything or need something to be scrolled or zoomed, don't be shy to ask, okay?
Okay.
Great. By way of introduction, can you just tell us a little bit about your educational background since college?
Well, I completed a bachelor's degree in biology from the University of North Carolina at Chapel Hill. I then completed medical school at the University of North Carolina in Chapel Hill. I then completed a internal medicine residency at the University of Chicago, where I stayed on to complete a 2-year postdoctoral fellowship in health services research called the Robert Wood Johnson Clinical Scholars Program there at the University of Chicago. I then joined the faculty, and by agreement, in the first year of my being a faculty member, I completed the McLean Center for Clinical Medical Ethics Fellowship in Clinical Medical Ethics.
Great. And tell us a little bit about your work history. What positions have you had along the way?
So after that training, I joined the University of Chicago faculty in internal medicine. I, for several years, practiced general internal medicine, both as an outpatient primary care physician and attending on the wards roughly 1 month per year. Several years after that, I don't remember the exact year, I joined several colleagues in forming a new palliative medicine consult service at the University of Chicago. And through continuing medical education type study as well as practice, then sat for the boards in hospice and palliative medicine. And for the past roughly 15 years, I have practiced primarily hospice and palliative medicine at the University of Chicago through the end of 2013 and at Duke University since the beginning of 2014.
And do you have any licenses and certifications?
I do. I'm licensed as a physician in the state of North Carolina. I am board certified in internal medicine from the American Board of Internal Medicine, as well as in hospice and palliative medicine.
And do you conduct research?
I do. I have conducted quite a bit of empirical research, particularly in the first half of my career in academic medicine, on physicians' self-reported beliefs and practices regarding contested practices in medicine. And I've had a particular interest in how those track along their religious characteristics, including being not religious. And then over the past, or the second half of my career, I've continued some of that, but have been doing more analytical research in the area of medical ethics and the intersection of medicine, ethics, and theology.
And have you made any peer-reviewed publications along the way?
I have about 150 peer-reviewed publications at this point.
And have you reviewed other people's publications as part of the peer review process?
Yes, I have, for many different journals.
And tell the court, what sort of students do you teach?
So I teach with a colleague the Duke University School of Medicine's course on clinical medical ethics. And that is offered to third and fourth year medical students. It's an elective course. Duke does not have a required medical ethics course, except it does require second year medical students to have a half-day educational introduction to clinical medical ethics. And I, this year, was asked to also teach that, which I have done now twice. In addition, in the divinity school at the university, or at Duke University, I teach a course on healthcare and theological context, which is the students of which are primarily medical students, both from Duke and from other universities around the country.
And in terms of your medical practice, do you have a focus or an area of expertise?
It's internal medicine as a field broadly, and then hospice and palliative medicine as a particular focus within it.
Great. And in terms of your research and academic work, would you say you have an area of focus or an area of expertise?
So I'm an expert in medical ethics, and in bioethics, which is the broader field within medical ethics, within which medical ethics is probably the most significant subfield. I'm also an expert regarding the intersections of medicine, ethics, and religion. And I have published on a number of different ethical questions and disputes within the field of medical ethics.
And tell the court a little bit about those two concepts, bioethics and medical ethics. How would you distinguish them, and what are they exactly?
So bioethics is the field which addresses questions about how we ought to act and how we ought to live with respect to living things. So bioethics includes all manner of ethical questions regarding any living thing, including the environment as a whole, animals, and humans. Medical ethics is the field within that focuses on the questions that arise in the experience of illness and in the practices of medicine.
And within that, is reproductive care part of that?
Yes, definitely. They're, generally speaking, the two areas where ethical questions and disputes most often arise are with respect to sexuality and reproduction, and with respect to the end of life.
And have you testified in previous cases as a biomedical expert?
I have.
And approximately how many? And by testifying, I mean deposition, trial testimony, sworn testimony, like that.
I can't remember the exact number, but at least 10.
And for how long have you been doing that kind of work?
I was first called prior to moving to Duke in 2014. So roughly 10 to 12 years, I believe.
And for this case, are you being compensated for your work?
I am.
And what is your hourly rate of compensation?
It's $500 an hour.
Great. And what is it you were asked to do as an expert witness in this case?
I was asked to consider the claims, allegations made by the plaintiffs, specifically as they entail a claim that the regulations that are at stake in this dispute are not consistent with medical ethics. And so I was asked to consider those allegations and whether in fact these regulations are compatible with and consistent with well-established norms of medical ethics.
And what methodology did you follow in terms of formulating any opinions on this case?
So I go in with a background knowledge regarding medical ethics, including, as is relevant in this case, the issue of informed consent primarily. And then I reviewed the complaint as well as the affidavits of the experts that were called by the plaintiffs. I considered their what they claimed as to whether their arguments had integrity, whether they were including premises that were consistent with well-established norms and premises that are generally followed in the field of medical ethics, whether their arguments were internally consistent. And then I also reviewed again material that I'm pretty familiar with, but just to be clear about it, regarding the principles of informed consent in particular and other principles of medical ethics that bear on these issues.
And that background expertise that you just mentioned, is there a document that you created that summarizes your background expertise?
Yes, I submitted an affidavit in this case, and in that affidavit, I summarized my background and expertise.
Okay. And apart from that, do you have something like a resume or a curriculum vitae?
I have a curriculum vitae, yes.
Okay. And just for the record, that's exhibit number 33 in this case. So at a broad level, what are your opinions on this case?
At a broad level, my opinions are that the regulations in this case, specifically the requirement of a 24-hour period between accessing specified materials regarding abortion and other options that women have who are facing the question about abortion, as well as the requirement of screening for coercion, are consistent with well-established norms of medical ethics. That contrary to the plaintiff's claims, these regulations do not contradict informed consent, but in fact are conducive to and supportive of the possibility of informed consent.
And did you also review the physician-only requirement for licensing in the statute?
I did, and in broad terms, my judgment, expert judgment, is that limitation is not inconsistent with similar limitations that states make, and is consistent with a high regard for the health of women who are considering abortion and are going to suffer, some of them are going to suffer adverse side effects of abortion.
Sure. So we'll discuss each of those in turn. Let me ask you, as a bioethicist, are you familiar with the concept of ethical standards of clinical medicine?
Yes.
Can you explain that to the court as best you can?
Well, to be clear, it's not as if there's a concept, ethical standards of clinical medicine, that everybody agrees to use those exact words, but there clearly are ethical standards for clinical medicine. And those are standards that the profession has adopted over time as norms that help it keep from going awry, and particularly that help it respect patients' authority to consent to or withhold consent to any medical intervention, and that make sure insofar as possible that clinicians, when they act, are acting in a way that's consistent with their profession as as clinicians, as medical practitioners.
And informed consent, is that a component of these standards?
It is. I think informed consent is probably the least controversial, the most consensus, practical, ethical principle in medicine.
And in layman's terms, what is the concept of informed consent for patients?
In layman's terms, the concept of informed consent and the principle of informed consent is that a patient, as a matter of respect for the patient's bodily integrity and for their authority, should not have done to them any medical intervention without their duly informed consent.
Great. I'll ask my colleague to bring up Exhibit B on the screen. Let us know if you can see it once it's up. Judge, while we do that, it's my habit, my practice to move to qualify expert witnesses. So I would move to recognize Dr. Curlin as a expert in medicine, bioethics, and informed consent.
So I'll object to specific questions. My understanding is the position of practice is not to qualify. And yes, I would object to Dr. Curlin as an expert in medicine. I don't know what that is. To the extent we're including in medicine all subspecialties, I think Dr. Curlin's been very clear that he's an internal medicine doctor. He does hospice and palliative care. He's not an OBGYN. And so I think medicine is certainly overbroad. I don't know that the court needs to rule on that now. I don't think it'll become an issue in the questions, but if the court's considering it, yes, I have an objection to Dr. Curlin being qualified as an expert in medicine generally.
Were you
I'll
saying,
take that to mean no objection to bioethics and informed consent.
was that the parameters that you had?
I can drop medicine and just have
Okay.
bioethics and informed consent. Thanks, Your Honor.
Thank you.
Great. Dr. Curlin, can you see the document that's in front of you there?
I can, yes.
And do you recognize it?
I have seen this before.
And is it anything that you relied on in the course of working on this case and reaching your opinions?
I don't recall if I relied specifically on this statement of the principle of informed consent. But
Okay, we can withdraw that then.
Yeah, Your Honor, I would just object to Dr. Curlin just testified he didn't rely on this to it being shown and used with him.
That's fine.
Ask questions.
Like I said, we can withdraw it. Talk to us, doctor, just generally, how does the informed consent process work in reproductive care and specifically in abortion care?
I would object to foundation, Your Honor. Dr. Curlin hasn't testified. He's testified generally about informed consent, but he has not testified that he provides reproductive care, that he has done any research on reproductive care, that he has performed informed consent in a reproductive care setting. Same thing with abortion. If you want to talk generally, I mean, he's obviously an expert in bioethics, no dispute. If he wants to talk generally about informed consent, but if they're going to add the specific qualifier to abortion and reproductive health care, I don't think a foundation to that has been laid.
Mr. Fedinsky, can you lay the foundation?
Yeah,
for that?
sure.
Great.
Doctor, do you perform abortions?
no,
As a bioethicist, how is it that you could opine on abortion practice?
So as I mentioned before, issues in sexuality and reproduction and abortion prominently are, take up a lot of the conversation, teaching, discussion, disputes within medical ethics. And so I've been familiar with the disputes about abortion for 20 plus years as part of working as a clinical medical ethicist and teaching clinical ethics. I teach about the ethics of abortion, and I have in the past participated as a clinical ethics consultant regarding questions that arise in the practice of abortion. I have never sought informed consent from a patient for abortion, as I'm not an OBGYN, as was stated, and I don't practice abortion.
Are you familiar with literature about bioethics in the context of reproductive care?
I am, yes.
And is that something you use in the course of your teaching?
Yes, it is.
And is that something you use in the course of the consulting services that you do?
Yes.
So how does informed consent work in the abortion context generally?
So informed consent works in the abortion context in many respects, just as it works in any other context in which a medical practitioner proposes to do something to a patient, to intervene in some way on a patient. And the principle holds that before they do so, they need to make sure that they have disclosed and that the patient has had reasonable opportunity to consider information that is relevant so that the patient can understand what it is that this intervention will do, what its consequences are, what options there are for the patient as alternatives to the intervention, and what can be reasonably foreseen as the consequences of those as well. It also holds that the medical practitioner needs to pay attention to and have a reasonable degree of medical certainty that the patient has adequate comprehension of that information, and that the patient is not under any sort of internal or external force that would vitiate this consent being properly voluntary. And so the informed consent process proceeds with the goal that the patient is capable of giving a duly informed, comprehending, and voluntary consent to whatever the physician proposes.
And what, broadly speaking, patient interests are protected by this concept of informed consent?
Well, broadly speaking, the patient's fundamental interest in bodily integrity is protected so that the patient does not have done to them something that they have not consented to and consented to after being duly informed. It also preserves the patient's interest in their agency, or as often the language used of autonomy, that that what happens to them is something that is consistent with what they are willing to consent to or permit, and is not at odds with that. And then, of course, it protects their interests in their health, because every medical intervention, at least in principle, every medical intervention poses both foreseen benefits, or if it's intelligible at all, it's in pursuit of benefits, but also poses foreseen and sometimes unforeseen risks of adverse consequences. And so insofar as patients withhold consent after being duly informed, they are protecting themselves from the adverse consequences of whatever intervention the medical practitioner might propose.
And is informed consent a necessary component of all medical care?
Yes.
And are you familiar with how informed consent works in the context of, say, getting a flu shot?
I am, yes.
Okay, tell us a little about that.
Well, as I noted in my affidavit, I
I'm
recently.
sorry to interrupt. I just know where we're going. So Dr. Curlin's affidavit includes an anecdote about his experience as a patient getting a flu shot, his review and receipt of materials, and what he was required to do. I object to that testimony coming in. Dr. Curlin's testifying as an expert bioethicist. He's not testifying as an expert patient. His personal experience receiving a flu shot, what information he had to sign, the forms he had to fill out, is not relevant to the issues in this case around reproductive health care. It is not something that experts in the field of bioethicists would rely on, and he can't testify as a patient. This is not about him as a provider giving flu shots and what it took. It's literally an anecdote that earlier he went to Duke, he got a flu shot, they made him review forms and fill it out. And so it's entirely consistent with informed consent for patients to be required to do that. This isn't a proper subject of expert testimony, and we would move to exclude it under 702, Your Honor. Also relevance.
Mr. Padinsky?
Your Honor, that's a poor objection that proves too much. By that logic, we wouldn't be hearing about breast cancer screening. We wouldn't be hearing about genetic testing. We wouldn't be hearing about end-of-life care. We wouldn't be hearing at all about examples and illustrations of how informed consent works in the real world. That's the point of this line of questioning is how does it work in the real world? And I think as the finder of fact, the court will benefit from comparing and contrasting things like flu shot, breast care diagnosis, end-of-life care, reproductive care. That's the whole point of it. And I think the court has said it wants a fulsome record to really tease out these expert opinions and this concept of informed consent.
I do want a full record, but I have a concern that Dr. Curlin may be speaking outside of his expertise and speaking as a fact witness. What is your response to that part of opposing counsel's
Well, he hasn't
argument?
provided his answer yet. He can talk about what he knows both through personal experience and through his expertise and his job. A flu shot is simply an example of how informed consent works. I could use pharmaceuticals instead. I mean, so I don't see how it's unfounded for him to talk about, I personally went through this when I got a flu shot. I think we heard a few witnesses talk about their personal experiences.
So I think a couple distinctions, Your Honor. When we heard about end-of-life care, those were from experts talking about the process of getting informed consent from patients. They were talking about regulatory requirements. If Dr. Curlin was going to get up and talk about, based on his personal experience as a physician or a clinical ethicist, when he gets informed consent, he does X, no problem. That personal experience as a physician or an ethicist is certainly an acceptable basis for him to opine as an expert. The issue here is this anecdote is about his personal experience as a patient, right? That is not proper grounds for an expert to opine about the process.
Let me ask this, Mr. Fedinsky, is Dr. Curlin going to be opining about the informed consent process as an expert, even though it's from his own personal experience as a patient?
Yeah.
I'm going to allow it.
Could I ask the court reporter to read back the last question? Go ahead, doctor. Did you hear that?
I did not hear it.
Okay. Tell us about the informed consent process and getting a flu shot, please.
The flu shot I would use just as an illustration of a pattern that over my long experience in medicine, I think is indicative of how informed consent is done. And that is in this case that at Duke University, when someone signs up or someone wants to receive a flu shot, they receive an email. This is for workers, an email that gives them a link to go to an online specified set of information, which then they are required to look through and click through. There's no requirement that they focus on any particular part, but they must scroll through and click through that information, indicating they've had due opportunity to consider it. And then in the end, click a button to verify that they have had such opportunity, and then take that on their phone or print it out and take a printed copy to the clinic where the flu shot is administered, where then they're asked, do you have any further questions? And then if they don't and they consent at that point, they can have the flu shot. The point is just, this is a pattern that in my experience is it's not exactly this pattern in every case, but in many cases, when people are going to consider some intervention, they are given information either by the institution or by the specific clinician to consider in advance before they would give final consent to that intervention. Let's just take, for example, a surgery. There's going to be a confirmation of consent to a surgery before the surgery is done, at the point the surgery is going to be done. But there's a process before that generally where people are given information and asked to consider it. And frequently they're given information that's provided to everyone who is considering such intervention. And then they're given opportunity to follow up and see if they have further questions.
And in your research, have you seen that information well, how would you describe the way that information is presented in your experience or in your research experience? Is it standard? Is it individualized?
Yeah, so I was able to watch some of the earlier testimony by Dr. Spector Baghdadi, and it is true that informed consent needs to attend to the specifics of the particular patient and that to which he or she is being asked to consent. But it's also true that it is very ordinary practice widely across medicine to as part of getting to that point, give people standardized information. That includes frequently information that a given patient and even a given doctor might not think is relevant to that patient, but is given as an effort to, well, one, because it's to help not leave out things that could be, that we know are relevant to many reasonable persons. And it also is given because we frequently just don't know what is relevant to a particular person. And so it gives them a chance to look at all that information and then to follow up with whatever further questions they have.
And have you seen similar disclosures of information in the context of over-the-counter drugs?
Yes. In fact, well, virtually all prescription medicines, all of that I'm aware of, have required inserts that include a lot of information. In my view, it's a lot of information, much of which is not going to be reviewed by a given patient, much of which is probably irrelevant to some patients, but is disclosed as a requirement by the FDA in order to make sure that all reasonable persons are duly informed or have the opportunity to be duly informed if they so choose.
And do you have any knowledge about how the informed consent process works out in the field of genetic testing?
Well, I know from review of materials in this case that in Michigan, there is some produced by, I forget the name of your agency that's in charge of health, but is produced by the state agency focused on health to be disclosed to patients before they undergo genetic testing, or at least certain types of genetic testing, which in my view accords with the recognition that genetic testing, and I've seen this personally in my work as a medical ethicist, once it has disclosed information to a person, their life is never the same. It's an irreversible knowledge that changes their whole experience. And so I think it makes sense, recognizing what is at stake in that decision, that people really know, or at least have the opportunity to know what is at stake and what they can expect before they undergo such screening.
And similarly, do you have any knowledge of how informed consent works in the context of breast cancer treatment?
So I similarly reviewed materials from Michigan about this as part of my participation in this case, and I understand that Michigan likewise requires women, before they are treated for breast cancer, to have an opportunity to review materials, and the health department provides some standard materials, is to my knowledge, to make sure that they are duly informed. That again accords with my knowledge about breast cancer treatment. I'm not an oncologist, but I am a palliative medicine doc who's taken care of hundreds of women who have died from breast cancer over the course of my career. And I know that treatments for breast cancer have been changing, and the evidence of those treatments has been changing over the past decades, and that, for example, women who are terrified, understandably, of what they face when they're diagnosed with breast cancer, There's a concern that they not too quickly move to surgeries such as a radical mastectomy that may not be necessary, and that may not be the option they would consent to if they had time and information sufficient to consider all of their options and what's at stake with those options.
And the mastectomy procedure you referred to, is that a reversible procedure?
It is not.
And in the context of your work, have you seen how informed consent operates in the context of end-of-life care?
I have.
And tell us about that, please.
Well, sure. So I have, as part of my clinical responsibilities, I have worked as a medical director for Duke Hospice for about a decade. One of the medical directors, not the only one. And in that role, when people are referred to us to consider for admission to hospice, before we can begin even sending our team to initiate basic care that they would receive in hospice, we must disclose to them information about written information to everyone, regardless of what they're interested in, a set of written information as specified by Medicare that describes what to expect with hospice, gives them, they or their surrogate decision maker, time to consider that information, and then ask them we ask them if they have any further questions, and then if they don't, and we think they've comprehended and are acting voluntarily, they can then give consent to being entered into hospice. But a similar kind of process occurs with respect to any sort of substantial intervention, medical intervention in patients at the end of life, as in other contexts.
Great. Thank you, doctor. In this case, we've heard about ethical standards, we've heard about regulations, statutes, and the Constitution. Can you tell us in terms of informed consent throughout the jurisdictions you're familiar with, what sources of authority are there for regulating informed consent?
Well, so there is, informed consent is fundamentally, and I think first, an ethical principle. It proceeds because of widespread recognition that there are ethical goods at stake that must be protected. It is also affirmed in the law. And to my knowledge, in every jurisdiction, it is a matter of law that medical practitioners not act until they have received duly informed voluntary consent from patients. I'm not an expert in the law, but as part of being an expert in clinical ethics is learning law relevant to medicine. And in addition, I know from my experience working as a clinical ethicist that institutions themselves will set rules on how informed consent is to be carried out. They will specify the documents that are to be used frequently. I work part-time at present in the Veterans Administration Hospital, and it has multiple specified informed consent documents that are required to be used in particular cases, such as starting someone on opioids, and must be given to every patient, the specified information. Duke University has its own sets of specified documents. And sometimes states will specify their own model documents, as I know is the case, for example, in Texas, with a stipulation that if a physician or surgeon usually wants to be have a presumption of having been given informed consent before a procedure, they need to use these documents that are created by the state. And that is regardless of whether the physician agrees with everything in that document. And the state doesn't require them to agree. It doesn't require them to not say anything else, but it does require them to give at least that information.
Now, the right of informed consent, does that include the right to consider treatment options and for the patient to choose?
It does. It does not entail the patient having a positive right to choose whatever they want, but it does entail them having a positive or having a right to decline to consent to any particular option. And so to choose among those options that a physician thinks are reasonable and is willing to offer.
Understood. And you anticipated my next question, the right to refuse is included. Is that what you said?
Yes, it is fundamentally as we might say in ethics or law, a negative right. It's informed consent is fundamentally a right to refuse.
And that can be anything from an injection to a surgery, right?
Yes, an injection, a surgery, a medication, or as I said before, even something like starting a new form of home-based care.
Got it. And doctor, did you have the opportunity to review and form any opinions on Michigan's 24-hour waiting period for abortion care?
I did.
And what are your opinions on that?
My opinions are that that waiting period does not contradict the ethical principles of informed consent and is consistent with other kinds of ways that the informed consent process is regulated in other contexts.
Well, how do you respond to the charge that many patients know what they want and they're certain, and so why should they have to wait and be inconvenienced?
I think this is a really important point. Again, I saw in the plaintiff's materials as part of my review, and I saw, as I recall, Dr. Spector Baghdadi testifying about this, but this is really important. Certainty has nothing to do with informed consent. Or it is not what is, it is not the standard of when a consent is informed. Frequently, when patients face medical decisions, the decisions are difficult. Not even the doctor is certain what the right decision is. Decisions can be contested, and patients very frequently who are duly informed are uncertain of what to do. And yet that uncertainty is a feature of being adequately informed about the realities of what's at stake. Certainty is not in, to my knowledge, any, Dr. Spector Baghdadi did not rely on any authority to suggest that certainty is a standard for informed consent. I'm not aware of any authority in medical ethics who suggests that certainty is a measure of informed consent. Very frequently, the question is, has the patient received the information that a reasonable person, and that it is the range of reasonable persons from the vantage of the clinician, a reasonable person might consider relevant, and have they had an opportunity to comprehend it, and are they doing so voluntarily? That's the standard. Certainty is not to the point.
Do you believe the 24-hour time period imposes a burden on patients?
I won't say that it's not any burden, but it's the kind of burden that's really intrinsic to the informed consent process. Just having to sit down and listen to a doctor say, I need you to understand all that's at stake in this intervention, even if you don't want to, I need to tell you this, which frequently doctors do, can be a burden of sorts to patients, but it is part of the kind of usual and customary minor burdens that serve a very important ethical good. Namely, the patient doesn't have something done to them that they didn't fully understand, insofar as is reasonably possible, before consenting to it.
And is there room for doctors to have a so-called proper bedside manner when it comes to explaining the 24-hour wait period?
It seems to me there is. I certainly hope they will be characterized by that.
And I want to ask you the same line of questions about we've been calling them the DHHS materials, but the information disclosures about the risks and benefits of various procedures, the gestational development chart. Did you review that material in forming your opinions?
I did, yes.
And what are your opinions as far as the statutorily required disclosures?
In my opinion, these disclosures are really a model of even-handed, scientifically accurate provision of information that a reasonable person might want to know. I was struck that in my review of the affidavits and statements by the plaintiffs and their experts, that it was repeatedly claimed that these materials were false and misleading and tendentious. And I am also struck that they never showed, in my opinion, a single sentence that could be accurately described that way. And I hope the court will look at the materials themselves, because there is not a single sentence in there that they showed that was scientifically inaccurate. There's not a single sentence that they showed that, or that I saw in my review, that appeared to be tendentious or to be pushing a woman to continue her pregnancy in any way. And in fact, it seemed to me the materials bend over backward not to do that. For example, the materials say, I recall, that it is rare that a woman will experience negative emotions. It's in fact not rare. It was, as was made clear by the plaintiff's own expert, Dr. Biggs, that who cited a study in which a week after having an abortion, 24% of women, as I recall, had primarily negative emotions. And a substantial proportion of those did not think that the decision was the right one for them. So that the materials say it's rare, I think indicates a kind of attempt, a bending over backward to be as even-handed as possible and not to appear to push continuing pregnancy.
And in terms of the even-handedness, did you review the materials as far as assertions related to continuing the pregnancy and going through childbirth?
I did, and as I recall, I don't recall every detail right now, but those materials included, for example, a statement taking a number, which I think is somewhat problematic as a reviewer of health services research, but they take at face value that I forget the exact number, but that carrying a pregnancy to term involves a greater risk of death to the woman than does undergoing abortion.
Did you find any portion of the materials that you viewed as stigmatizing?
I did not see a single sentence that seemed to me reasonably construed as stigmatizing.
Did you find any portion of those materials that you viewed as slanted against choosing an abortion?
I did not find a single sentence that seemed to me reasonably so construed.
Now, the fetal gestational chart, the fetal development chart, did you review that as well?
I did.
And was it reasonably accurate?
To my knowledge, yes. Although I'm not an expert embryologist, but to my knowledge, yes.
Now, how do you respond to the charge that displaying this to a patient with a non-viable fetus is cruel, unnecessary, and there's no medical purpose for it? What's your reaction to that?
So it seems to me that this really important in the principle of informed consent is that the doctor must be candid and forthcoming, the medical practitioners, not hiding from patients information because the doctor believes such information might be uncomfortable, even though it's truthful. And here you have a case, namely abortion, elective abortion, in which what the procedure does, and it's a direct effects, is to remove, and thereby it's going to cause the death of the fetus. That's the central thing that abortion does. And it seems to me reasonable. And we know that to some women, we know from things that the plaintiff's own experts have acknowledged, that some women find that information very important. We know that some women, not a majority, but some minority of women, when they have a chance to consider that information, decide not to proceed with abortion. And that seems to me that those cases display objectively that information in those cases has contributed to informed consent for those women. And unless it can be shown, the plaintiffs have not shown, that such women are unreasonable, that they're outside the range of a reasonable person standard. And it seems to me clear that this is information worth offering to women for their review. Women don't have to look at it. They don't have to dilate on it. But for those who would find it relevant, it seems important to make it available. And no one can know in advance who might find that information relevant.
And the flip side of that, does displaying that information to the person who ends up being certain, ends up not changing her mind, does that process harm that person's autonomy or their informed consent?
You mean if someone continues with abortion?
Right. Right.
To me, it does not. To me, it has enhanced, as has been argued by bioethicists over the years, it has enhanced their consent by giving them information about what it is that's at stake. Um, it it allows them to be more duly informed.
And did you also review a coercion screening component of the Michigan law?
I did.
And what are your opinions on the coercion screening component?
As I recall, the requirement is that some coercion screening must be done, and then the state agency provides some model language for that. It seems to me that that is a reasonable requirement. One of the three, and this I think is a consensus issue among medical ethicists, not contradicted by the plaintiffs, one of the three criteria for informed consent is voluntariness. Data that I think has been agreed upon by both sides in this dispute makes clear that some women feel pressure to undergo an abortion. And as has been acknowledged, we can't always know for sure which women those are just by looking at them or even asking. But this at least gives an opportunity for women to indicate that they are under pressure and for the clinician to take that into account, because a coerced consent is not consent.
And does the coercion ever run in the other direction in favor of continuing the pregnancy and going through childbirth?
It certainly does. I don't think that was a subject of focus in the materials, but certainly coercion could go either direction.
And from your point of view, did you find anything problematic at all in the coercion screening component of the Michigan law?
I did not.
Now, the final component of the law I'd like to ask you about is the statutory licensing requirement of the law. Are you familiar with that part of it?
I am.
And what are your opinions on that part of it?
So my understanding is that only physicians are licensed in Michigan to carry out an abortion, not advanced practice clinicians. And my opinion is that such restrictions are, my opinion is not that it would be unethical if any state were to allow advanced practice clinicians to develop the expertise and the freedom to do abortions, but that it is consistent with ordinary practices in medicine and a high regard for the bodily integrity of women and their health to limit a practice like abortion to those who are most able and most trained to deal with its complications. The key issue in any medical intervention is not just what happens in the average case or the usual case, but what can be reasonably foreseen as likely to happen sometimes in unfortunate cases. And with respect to abortion, we know that in unfortunate small minority of cases, there can be serious complications, and OBGYNs have more, or other physicians have more experience, at least on a prima facie consideration. They have more experience dealing with such complications.
And so what do you understand is the point of restricting abortion care provision to physicians?
Objection, Your Honor, lacks foundation. If he's asking what the point is of why the Michigan rules do this, there's no foundation that Dr. Curlin understands the legislative purpose or basis for it. If he wants to ask what the impact is, I have no objection, but getting to the intent behind it, I don't think Dr. Curlin at this point has the necessary foundation to provide that.
I think he just said states can choose if they want APCs to get training and do it, or they can choose to restrict it to doctors, and he has no problem with that. So I'm asking him, what's the point of restricting it?
Can you focus the question on the impact as opposed to his opinion on something that's outside of his expertise?
Yeah, sure. How do patients benefit from the physician requirement?
Well, they would benefit by having the abortion care only offered by people who are more highly trained. I note that part of this, the amendment to the Constitution in Michigan is an affirmation of full autonomy regarding one's sexual and reproductive future, and some complications of abortion, thankfully, are rare, but can affect future childbearing. And insofar as such complications are expertly managed, that helps to ensure, ensure women's autonomy, not just in this moment, but in their futures.
And is safety related to autonomy in this context?
Well, yes, insofar as if someone suffers a complication that removes the possibility of further childbearing, then just to that extent, their future ability to bear a child that they may want is removed.
And you mentioned complications arising from abortion. What is the significance of who responds to those complications?
Well, in this case, it's just a question of to the extent reasonably possible, ensuring that those who respond have the expertise and experience to do so well, and to thereby best ensure the future reproductive health and integrity of the woman.
Did you base any of your opinions on your personal views about abortion?
I did not.
What did you base your opinions on?
I based them on my understanding of the medical ethics literature and my understanding of the clinical practice of medicine and its ethical norms, developed over the past 2+ decades.
And are your opinions within a reasonable degree of certainty within your field?
Yes, they are.
Thank you, Your Honor. I'll pass the witness.
Okay, thank you very much.
Thank you, Your Honor. I just have 1 second to set up.
Sure.
Thanks.
Dr. Curlin, do you need to take a break? Or are you okay to continue?
No, I'm good now. Thank you.
Get a full workout in today. Good morning, Dr. Curlin. Can you see me this way, or are you still looking at the back of my head?
No, I see you facing more or less my direction.
Okay, I was going to turn around so you weren't just seeing the back of my head, but my name's Megan Kelly. I represent the plaintiffs. It's nice to meet you.
Thank you.
Preliminarily, we sent you some binders of materials that I understand were delivered to the location of your choice. I'm sure you were excited to get to pick where they went on Saturday. Do you have those with you today?
I do, and I've in fact been lugging them back and forth to my house for the past 3 days, hoping not to get snowed in and have to have them. But I have them all here, three binders.
Perfect. I appreciate that. Glad that we could help with a little cardio for you. If we need to look at them, I'll let you know. I just wanted to make sure you had them, okay?
Thank you.
Dr. Curlin, your board certifications and clinical practice has focused exclusively on internal medicine and hospice and palliative care. Is that correct?
That's correct.
Your primary area of academic and research interest is the intersection of medicine, religion, and ethics, right?
Yes, that's my sort of subspecialty within the field of medical ethics.
And the focus of your publications, you talked about your peer-reviewed publications, and I know you have other publications too. The focus of those has been on the relevance of religious ideas and practices to the doctor-patient relationship, the moral and professional formation of clinicians, care for patients at the end of their lives, and medical ethics, right?
Yes, with all of those are areas I've covered, yes.
You agree, Dr. Curlin, that abortion is a common procedure and relatively safe for women who undergo it, right?
I do.
You've never performed an abortion. I think you made that clear, but just so it's unambiguous.
That's correct.
You don't have expertise in the clinical practice of abortion, do you?
I do not.
And you aren't an expert in the clinical practice of obstetrics and gynecology, are you?
I am not.
You told us earlier you've never personally obtained informed consent for an abortion, have you?
I have not.
You have no personal experience advising patients of the potential risks associated with any abortion, whether it be medication or procedural, do you?
Not at a point where they are considering the abortion directly.
You've never personally observed another medical provider obtaining informed consent for abortion, have you?
I have not been in that clinical context, no.
You mentioned a few times when you were talking with counsel for the intervening defendants, your practice as a clinical ethicist. Do you remember that?
I do.
You haven't provided clinical ethics consults since you were at the University of Chicago, have you?
I haven't served on a clinical ethics consult team, but I have actually been a part of the formation of clinical ethics consults at Duke.
Right, but that's not part of your practice. You're not the person who gets paged if somebody at Duke needs a clinical ethics consult. You haven't done that since you left University of Chicago. And was it 2013 or 2014?
I left at the end of 2013. And yes, that's right. My colleagues have brought me into their own deliberation about clinical ethics consults, but I have not been the person holding the pager. That's right.
Your familiarity with the clinical standard for abortion care comes entirely from your work as an expert witness on behalf of states in abortion cases and from reading declarations that other doctors filed in those cases, right?
There was a lot combined in that statement. I'm not sure I can affirm that. Maybe you can break it apart.
Sure. So you have some familiarity with the clinical standard of care related to abortion. Is that fair to say?
Yes.
And where you got that familiarity is based on declarations that you've read in serving as an expert for states in abortion litigation. That's the only place you've gotten that expertise, right?
No. I've also gotten that expertise from my own training in medical school, including rotations in OBGYN, as well as clinical ethics consultations and discussions over the subsequent couple of decades.
All right, Dr. Curlin, I'd like you to get the binder that says volume 1 of 3, please.
Sure. I have it.
And in there, if you could flip to what's labeled as Plaintiff's Exhibit 51, it's the deposition testimony that you gave in this case.
Okay.
Did you find the tab?
I did.
If you could turn to page 81, it's lines 20 through 82, line 11. It's hard to see, Dr. Curlin. Just so will you let me know when you're there? I don't want to start.
Yeah, sorry, I will. Yes, you said page 81.
Correct.
What line?
We're going to start at line 20. So you're familiar with the clinical standards for informed consent for abortion? Answer, yes, just as I described. Where did you gain that familiarity again? Because I don't think I understand. And your answer was, so as I said, I've been called as an expert witness in a number of cases involving abortion. I've read now many hundreds of pages of declarations by abortion providers in which they describe how they go about informed consent. And based on my reading and paying close attention to what all of these abortion providers describe as their characteristics, practices of how they go about informed consent, I believe I have expertise regarding how abortion providers characteristically go about informed consent, at least according to their own descriptions. Did I read that right?
Yes, you did. But the difference, the reason I had you pause was you had asked the question that is the only way I have any familiarity. And that's not what I said here. I said I have this experience, which, gives me substantial, I think, familiarity with what abortion providers themselves say is their standard practice.
Dr. Curlin,
that's not the only, my point was that's not the only context in which I have learned about this practice.
Right, but in response to a question in your deposition where you were asked about where you got this familiarity, the only thing you identified, at least when you were under oath in November, was your work as an expert witness and declarations you had read, because I just read that answer to you, right?
Yes, and you didn't ask in this deposition, is there no other area where you have gotten any expertise? So if you were asking me to be utterly comprehensive and make sure there was nothing else included, I would have answered differently.
Okay, good to know. In every case where you've testified as an expert witness and in every abortion case, you've testified that the abortion restrictions that were being challenged should be upheld, right?
No, more specifically, actually, I have testified to the best of my recollection in each case in which I've been called regarding an abortion regulation and it being disputed. I've testified that the regulation is, in my view, consistent with the norms of medical ethics.
And you testified that those, I'm sorry, Dr. Curlin, I didn't mean to interrupt you.
Reasonably understood.
Okay. And you've in fact testified in every one of those cases that the abortion restrictions don't violate ethical principles as well, right?
So as I just said, in the cases that I've been called and the regulations I have seen, it has been my opinion that the regulations do not contradict well-established norms of medical ethics, contrary in those cases to the claims put forward by plaintiffs.
And the cases you've testified where abortion restrictions don't violate ethical principles include in Indiana, Georgia, Kentucky, Kansas, and multiple times for the state of Texas, right?
Yes.
You mentioned on your direct that you're charging the taxpayers in Michigan $500 an hour for your testimony here. Is that right?
That's right.
How much total have you billed Michigan taxpayers for your work on this case?
I believe it was around $21,000.
How much total have you charged taxpayers of Indiana, Georgia, Kentucky, Kansas, Texas, and Michigan for your opinions that abortion restrictions don't violate ethical principles?
I actually don't know the answer to that question. I haven't tried to sum that up.
Do you have a ballpark figure? And if you don't, that's okay. Just trying to figure out.
I don't, but I've charged some $400 an hour and some $500 an hour.
In coming to the opinions you have in this case, as you laid them out in your declaration, you didn't speak to any other doctors, including doctors who perform abortions, right?
Not that I recall.
In coming to your opinions in this case,
I just want to be clear, since I'm under oath, I'm talking to doctors all the time, including about ethical questions, including about abortion. I just taught about abortion to the Duke School of Medicine students this week. So I have talked to doctors about abortion, but I don't recall having a specific conversation with a doctor about this specific case, informing my opinions.
okay. So is it that you don't recall or that you didn't do it?
Well, I'm telling you, I don't have a memory of such conversation, but because I talked to so many doctors about what I'm up to and the issues that are involved, I cannot positively tell you with certainty that I haven't talked to a doctor about the questions raised in this case.
Absolutely. The topic may have come up, but that's not something you did to come to the opinions you have in this case, right?
That's right.
Okay. You also, in coming to your opinions in this case, didn't talk to anybody who had an abortion, did you?
I did not.
You didn't consult any medical textbooks in coming to your opinion, did you?
I did consult the most influential textbook of biomedical ethics.
All right, doctor, let's go to tab 51 again and binder 1, please.
Sure. Is that the same tab?
Yeah, it's the same one. It's going to be page 43.
Great.
Are you there, doctor?
I am.
I feel like I'm like calling to you from space when I ask, are you there? I meant, are you on the same page with me? Not, can you hear me now?
Yes. I'm on page 43, yes.
Thank you, Dr. Curlin. Line 22, you were asked, did you consult for this report any medical textbooks? And your answer at your deposition was, I do not recall doing so. Did I read that right?
You did. To clarify, as I said, and as I cited in my affidavit, which you would have had in order to do this deposition, I had consulted the Principles of Biomedical Ethics, which is the most influential textbook on biomedical ethics. So Is that a medical textbook? It's not a textbook about specific clinical medicine, which is probably what I had in mind here when I answered. I do not recall doing so. It's not a book on OBGYN or a book on, particular type of surgery, but it is a textbook that is used in training medical practitioners.
Dr. Curlin, you have no information on the details of the scope of practice of nurses in the state of Michigan, do you?
Not the details, no.
You also don't know any specifics about the scope of practice for physician's assistants in the state of Michigan?
I don't know if that's any specifics. I mean, I know the specific that as I understand it, they're not, it's not included among their lawful scope of practice to practice abortion, but I don't know other specifics.
Right, you're talking about the regulations at issue here. Beyond what's in the challenged regulations, you don't have any information about physician's assistant scope of practice in Michigan, right?
I don't remember the details. I think I reviewed some of the scope in terms of their ability to prescribe medications, but I don't remember the details of that.
That's fine, we can move on. You mentioned you watched Professor Spector's testimony. What other parts of the trial did you watch?
I watched kind of coming in to see where we were in the process, a few minutes each time of Dr. Wubenhorst's testimony. And similarly, I watched, I don't know how much, maybe 10 or 15 minutes of the end of Dr. Is it Bagdasarian? Her testimony. And I don't think I saw all of Dr. Spector Baghdadi's testimony, but I saw a substantial portion of it.
You didn't have the last 5 days to hang out watching YouTube all day, had some other day jobs to do?
I did.
All right, Dr. Curlin, we're going to talk about the specific regulations and requirements that are being challenged in this case in a second. But one of your opinions in this case is that the state can require specific information to go to patients who are seeking an abortion, rather than just relying on abortion providers to decide what to disclose, because abortion providers have a vested interest in their particular approach. Is that correct?
That's part of it.
And because there are inherent biases related to abortion, you believe it's
May I just clarify? I think states have a general authority to require disclosure of information with respect to medical interventions, a reasonable authority, and it doesn't violate medical ethics that they do so. I also think that a factor in why they might want to do so in the case of abortion, as with other interventions, is that the practitioners of the intervention in question have a vested interest in it. That's not uncommon. It happens a lot in medicine.
And because there are inherent biases related to abortion, you think it's reasonable for the state to try to make unbiased information available to patients, right?
I do, but specifically because abortion is such a contested practice. And as I noted in my deposition, abortion providers, I expect, believe that abortion is ethical. And that means that they are with what it sounds like the majority of Michiganders. Michiganders, sorry about that. But not with all.
I believe our two newspapers don't agree on that.
Sorry, but not with all. I mean, this is deeply contested even in Michigan as it is elsewhere.
Safer to say in Michigan than with the folks in Michigan. When it comes to abortion, Dr. Curlin, you think that one's posture towards abortion can affect what one sees, right?
Sure, yes.
In fact, in your declaration, you actually criticize Northland Family Planning because you think that Northland's support for abortion is making it hard for them to see the truth, right?
I specifically, I believe they testified that they, in all of these years, have never seen it benefit a single patient to have, as best I recall, a waiting period and the disclosure of the required information. And that suggests to me that they are not able to see that, because it seems to me implausible, if they're doing very many abortions, that no patient has found that waiting period or that information helpful.
All right, doctor. So I want to talk a little bit about some of the views you have towards abortion in light of all of that. It's your opinion that the provision of abortion care at any point in pregnancy is unethical, right?
To be specific about this, I've testified, repeatedly and written, and it is my judgment that it's never fully reasonable to intentionally kill another human being, even a teeny tiny one. And in that respect, it's never fully reasonable. It's never fully ethical to engage in an elective abortion. At the same time, I recognize that one, that's a contested question, and I recognize that people can undergo abortion for all kinds of reasons that may make their decision to have an abortion not blameworthy. But it's never good that human beings are intentionally killing another human being that's innocent.
In your opinion, Dr. Curlin, an embryo is unequivocally a human being, right?
Unequivocally, yes, that's a scientific fact.
And you believe that anyone who says a fetus is not a human being is outrageously unreasonable and unscientific, right?
Well, I think that claim is outrageously unreasonable and unscientific. I mean, what else would the fetus be if not a human being?
Your opinion is that elective abortion is unethical unless it is to preserve the life or health of the woman, because otherwise it's an intentional killing of an embryo, right?
Specifically, that would not be an elective abortion, as I understand it. That would be a justified abortion on the basis of the intervention is done to preserve the life and health of the woman. I think there are certainly cases in which that is ethically justified.
Right. So what's ethically justified, in your opinion, is an abortion that's performed with the intention of preserving the life or health of the woman. But if it's not done for that purpose, in your view, it's unethical, right?
It's not fully ethical. It may be not particularly blameworthy. It may be something that should be lawful, as I've testified elsewhere. But insofar as people are intending to kill another human being, I just don't think that intention is ethically justifiable, although it is understandable in many situations.
All right, Dr. Curlin, if you could pull out binder 3 of 3.
Sure. Excuse me. I have that binder.
Okay, if you could go please to tab 214, which is Plaintiff's Exhibit 214, trial testimony that you gave in a Texas case in 2018, and turn to page 78, please.
I am at page 78.
All right, we're going to look starting at line 1. And in your opinion, the respect that we owe an embryo makes induced abortion unethical, except to prevent grave risks to the health of a woman, correct? Your answer under oath was yeah. In my judgment, it is unethical to intentionally kill an embryo or fetus unless it's part of a process to preserve the life and health of the woman. Did I read that right?
You did. That is exactly what I was trying to communicate just a moment ago.
Sorry, Judge, was that impeachment or just confirming what he said?
I think that they were trying to suss out if there was any distinction between what he said. So it's good to have on the record that it's consistent.
Okay, I object to improper impeachment.
Your Honor, he would not say it was unethical. He kept saying it was not fully ethical, which is different than being unethical. In that testimony, he unequivocally stated that abortion was unethical, which is something he's refused in response to multiple questions that I've been asking, which is why it's impeachment. Dr. Curlin, you do not think that abortion is ethical, even in cases of rape or incest, correct?
As before, I don't think in these tragic cases that it is fully reasonable, even in these tragic cases, to intentionally kill the fetus. Though, as I've testified before, I don't think it necessarily should be unlawful. And in fact, it's my opinion now, which has been forming over time, that it probably should be lawful because of the experience that women have in these situations, not only being violated, but of feeling understandably that to carry the baby to term is to effectively have their life come apart. It is still my opinion that insofar as possible, if we can create the conditions where women don't have to make that choice, we should, because to intentionally kill this new human being is not fully reasonable.
Dr. Curlin, you're not a lawyer, are you?
I am not.
Right. And none of my questions, you understand, have asked you about whether you think something should be legal, right? All of my questions have been about your ethical opinions. Do you understand that?
I do. Thank you. Yes,
Okay.
I agree.
All right. So let's take a look, please. Binder number 1, tab 198, which is Plaintiff's Exhibit 198. This is a deposition that you gave in a Kansas abortion case just about 2 months ago on December 10th, 2024. Do you recall giving that deposition?
I do, yes.
Great. Let's go to page 99, please.
Sure. I am at page 99.
So line 22, you're asked, so in your judgment, if a person were to become pregnant as a result.
Sorry, I'm not seeing that, what you're reading at line 22.
Okay, so Dr. Curlin, are you looking at the page numbers on the bottom? I'm looking at the page number in the box. I'm sorry. This is one where there's not a quite one-to-one correlation.
Now I am on 99 in the box and line 22. Go ahead.
Okay. You were asked, so in your judgment, if a person were to become pregnant as a result of rape or incest, again, your personal judgment is that the ethical outcome would be for her to carry the pregnancy to term and deliver that pregnancy, correct? Your answer is, well, the way I'd put it is this, and it's not a personal judgment, although it is a judgment I personally share, is that I have not seen a persuasive argument as to why it is justifiable in the end, or why killing the fetus resolves the ethical tragedy and injury that a woman has suffered. So is this an area where there should be a lot of room for people to make very difficult decisions, including a decision for abortion? I think it could be, given that states have to respect what the people, what the people can tolerate and what fits the kind of formation that they've received. But I don't think it's fully reasonable in the end to try to resolve this horrible thing by doing something that involves killing an innocent human being. Did I read that right?
You did, and I just would want to highlight my statement just prior to that question.
When I'm done, counsel for the intervening defendant's going to get a chance to get back up and ask you to clarify anything that you want to. So I'd ask that you try to just answer the question I asked. Did I read that right?
You did read that right.
Thank you. Dr. Curlin, in your opinion, abortion isn't medicine unless it's intended to and likely to preserve and restore a woman's health, correct?
That's correct.
In your opinion, elective abortions are not a medical procedure, correct?
In that understanding of medicine, that's correct. I take, just to clarify my answer, I take that to be a consensus understanding, and that's why the term elective is used.
Your Honor, I'd move to strike everything after yes. I didn't ask what the consensus opinion was. I asked what Dr. Curlin's opinion was, which is that elective abortions aren't a medical procedure.
I will take that into consideration.
Dr. Curlin, any abortion, in your view, any abortion that isn't necessary to prevent a grave injury to a pregnant woman violates the physician's profession, right?
In my judgment, any abortion that is not necessary as a part of a physician's profession to act in a way that's consistent with the patient's health just to that extent, violates their profession.
You believe that abortion providers are killing innocent human beings, don't you?
I think it's an unfortunate fact that the fetus is an innocent human being and that those who kill it are killing, therefore, an innocent human being.
So you agree with me that it's your view that abortion providers kill innocent human beings? The answer to my question is yes?
Anyone who kills an innocent human being, including abortion providers, is killing an innocent human being. That's kind of a tautology.
You believe that it's your fundamental obligation as a medical ethicist to speak up about ethically weighted issues like abortion, right?
I do believe that is a part of a medical ethicist's obligation, yes.
You do not check your personal ethical commitments at the door, and you don't believe that any physician should do so, do you?
To answer that, I think I have to qualify, knowing how these words are misunderstood, or you can show me the context where I said that. Because I certainly agree with that. Yeah.
Sure. Dr. Curlin, why don't we go to, we're still on tab 198,
Okay.
page 87,
Yes. Hang on one second.
and it's 87 in the box.
I am at 87 in the box.
And you see, starting at line 1, your answer, you state, but I don't check my ethical commitments at the door, nor should any physician do so in our judgment. That was your testimony just 2 months ago?
Can I have a second to see what question was being asked?
Sure.
I don't
And I
know
can
if
put it on the record. It's page 86, line 1.
Am I want to be clear. I don't want to violate the rules of the court. Am I not allowed to point to the context of my answer? Because I won't.
I'm sure that intervening defendants counsel will give you that opportunity.
Okay.
Dr. Curlin, you try very hard in your work and in all dealings of your life to carry your religious beliefs into that, correct?
In a certain manner, yes.
All right, Dr. Curlin, let's go to tab 196 in that same binder. That is Plaintiff's Exhibit 196. It is testimony you gave in a trial in Kentucky in 2018. And if you turn to page 5.
Sorry, which page?
Page 5.
Thank you.
One moment. Okay, I think I am there.
It's the same. This is not one of the confusing ones. Line 24, you're asked, and you also agreed, Dr. Curlin, that you try hard to carry your religious beliefs over into all of your other dealings in life, right? And your answer was, that's right. Did I read that right?
Yes, and I was acknowledging that if I was put that question on a survey, because that is a question from a survey, that I would agree with it.
Dr. Curlin, you agree that nothing is as important to you as serving God as best you know how, correct?
Your Honor, I'm going to object under Rule 610. Evidence of religious beliefs is not admissible to impeach or enhance credibility.
So, Your Honor, that's actually a misunderstanding of Rule 610. Rule 610, the commentary specifically states that it prohibits the introduction of evidence for the purpose of impeaching a witness's credibility, but the evidence is relevant. It does not prevent evidence tending to demonstrate bias or interest on the part of a witness. This clearly goes to Dr. Curlin's bias. Additionally, Rule 610 states that it is consistent with federal rules 610, and the commentary to the federal rules states that it forecloses inquiry into religious beliefs for the purpose of showing a character for truthfulness. But inquiry for the purpose of showing interest or bias because of religious beliefs is not within the prohibition. Further, I would cite, Your Honor, to People v. Jones, which is 82 Mish App 510 at page 516, which states that the purpose of 610, quote, is to strictly avoid any possibility that jurors will be prejudiced against a certain witness because of personal disagreement with the religious views of the witness. Dr. Curlin, testimony was elicited that he's totally unbiased and was neutral. Your Honor has an obligation as the finder of fact to challenge that. I'm going to, after Dr. Curlin answers this, put some publications where he talks about what his duty is as a physician. He has testified that his area of research involves religious beliefs and physicians' trainings and the development of their skills. This goes not to whether he's a religious physician or not, but what he believes that means and requires, which is directly relevant to the issues at, I was going to say at issue, but that would be a terrible sentence. The issues in this case, it goes to credibility and bias. There is not a blanket prohibition under 610. Further, I would note, these are questions that Dr. Curlin has answered in multiple trials in multiple other states. They have been permitted.
I'm happy to refer to other proceedings and personal experiences as an attorney like that, Your Honor. That's like testifying. And I would simply read the rule. Rule 610, evidence of a witness's religious beliefs or opinions is not admissible to attack or support the witness's credibility. And there's nothing about federal staff comments as being controlling.
My understanding of the rule is that while a person's religious beliefs cannot be used to attack, is not admissible to attack or support the credibility, I think in this case it does go to bias. And Dr. Curlin has put that within the scope of his expertise, since part of his research and review and what he does for a living involves this intersection of biomedical ethics and religious beliefs and his religious beliefs. So while it is not being used to attack or support his credibility, I think it does go to his bias and his the heart of his expert opinions in this case.
Dr. Curlin, there is nothing as important to you as serving God as you best know how, correct?
Yeah, I mean, I'm a Christian, and so by definition, I think if you understand Christianity rightly, you know, it's fundamentally important to be faithful to God, period.
And you've agreed, you were talking about that survey when we were looking at Plaintiff's Exhibit 196. On that survey, you agreed that nothing is important to you as serving God as best you know how. That's how you answered that question, right?
Yeah, I think I don't remember exactly, but I'm guessing I would have indicated that if I were put that question on the survey, I probably would have said I agree.
All right, Dr. Curlin, I want to take a look at one of your publications, and I didn't include this in the binder, so we're going to screen share it. This is I
just lost the sound.
Can you hear me now?
I can, yes.
I didn't think I was handing things. I realized you now can't see us. I was handing things to Her Honor and to opposing counsel. So sorry, I stepped away. Can you see what's up on the screen, Dr. Curlin?
I can, yes.
Okay, this is Plaintiff's Exhibit 296, which is an article that you are a co-author on entitled Solidarity, Trust, and Christian Faith in the Doctor-Patient Relationship, that was published in the Journal of the journal's title is Christian Bioethics in 2021. Can you see that?
I can, yes.
Okay. And Ms. Willingham, who is doing an amazing job as my stand-in tech assistant, if you could please go to page 11 of Plaintiff's Exhibit 296. I want to take a look at some of the things you wrote. Any chance we can make that a little bigger at the top? Oh, thank you. So we're going to start with the first sentence there. Can you kind of see that, Doctor?
I can.
Oh, great. Okay. And what you wrote in 2021 was, the Christian physician must see herself as ultimately called not by either the good of health in the abstract, nor even the good of health in this particular person, but called by God to minister to this particular person's health in service to a relationship of friendship with God. Did I read that right?
You did read that right.
And we're going to go to the next paragraph. And the first sentence that you wrote there says, from this standpoint, everything that the physician does with and for the patient is also for the sake of friendship with him. Him is capitalized. Him refers to Christian God. Is that right?
To God, yes.
Well, Christian God, right? God as Christians use it.
Yes, in this, yes, of course.
For the sake of his heavenly kingdom and for the sake of life with the triune divinity of Father, Son, and Holy Spirit. Did I read that right?
Yes, that's correct.
And the statements in this article, Dr. Curlin, are an accurate reflection of your views, correct?
Yes.
All right, Dr. Curlin, I want to start talking about the 24-hour waiting period that patients are required in Michigan to wait. Terrible question, but do you get the point? The 24-hour waiting period. Let's start talking there, okay?
Sure.
The entire basis for your opinion that the 24-hour delay requirement protects patient health is logic and your long experience and understanding of medicine, right?
Can you, it sounds like you're quoting me. I mean, that's not the entire basis. It's also the data that is disclosed by the plaintiff's own experts in this case. But logic certainly contributes to it, as well as my clinical experience.
Okay, well, let's go please to Plaintiff's Exhibit 51, which is your deposition in this case. It's binder 1, Dr. Curlin.
Which number is it again?
It's binder 1, Exhibit 51.
Okay, I'm there.
Page 29.
Okay, I think I'm on page 29.
Okay, and you're asked, starting at line 23, what is the basis of your opinion? You responded, of which opinion? The questioner asks, of your opinion, the 24-hour waiting period may protect some patients from the adverse effects of having an abortion. And your answer was, well, the basis is logic and long experience in understanding medicine. I mean, particularly that every medical intervention has, if it's reasonable to try it, has foreseen benefits, but it also has risks of adverse events. And it's also an understanding of abortion in particular, including the information that the patients relied on, which indicates incidence of different complications of abortion. Did I read that right?
You misread 2 words within it, but otherwise correct.
In coming to your opinions on the 24-hour delay period, you didn't review any literature about the impact 24-hour waiting periods have on access to abortion, did you?
I reviewed, as best I recall, literature that was cited by the plaintiff's experts.
Did you specifically go out on your own before coming to the stuff in your declaration and your opinions that you laid out? You didn't go out and review any literature or cite any literature on the impact of the 24-hour waiting period in your report, right?
No, I don't think I can agree with that. As I said, I looked at, well, I bring to this knowledge, some knowledge about waiting periods. And I looked at the data that was relied on, or I should say the references, the publications that were relied on by the plaintiff's experts and some of the claims they made. I can't say I looked at everyone, but I looked at some of those.
Not every patient needs to wait 24 hours after deciding to undergo an abortion to have the procedure, in your opinion, right, doctor?
Needs in what respect?
I'm asking needs generally. You have the opinion that not every patient needs to wait 24 hours after deciding to undergo an abortion to have the procedure, correct?
Well, certainly patients who have a medical condition for which waiting to end the pregnancy poses some substantial adverse risk should not be asked to wait. And my understanding is the law permits that. And it is not my testimony that it is impossible for a patient to provide informed consent without waiting 24 hours. It is my testimony that waiting 24 hours, in the same way that it's not impossible for a patient to give informed consent without a handout, notwithstanding that being a common practice. It is my testimony that the waiting period as the handout does not vitiate informed consent. It's consistent with a commitment to informed consent.
Right. So you'd agree with me that not every patient needs a 24-hour waiting period to give valid and ethical informed consent before they can have an abortion procedure, right?
I do agree.
Great. You agree that even for those patients who might benefit, well, let me ask it this way. Waiting less than 24 hours could provide the same opportunity for patients to make a considered decision that you see as being one of the benefits of the 24-hour waiting period, correct?
Sure. I mean, 24 hours is not a magic number. It's a reasonable number, but it's not a magic number.
In fact, you've testified in another case that an 18-hour waiting period provides the same benefits that you believe a 24-hour waiting period provides, correct?
I don't remember what I testified about that, but I do believe that an 18-hour waiting period likewise is consistent with the principles, ethical principles at stake in informed consent.
There can be burdens associated with making patients wait some period of time before they get an abortion, right?
Yes.
Including burdens like having to make a second trip to an abortion clinic, right?
That's possible. Yes.
The clinical standards of practice do not require a 24-hour waiting period for every procedure, correct?
That's correct.
If Michigan law did not mandate a 24-hour waiting period, physicians could be acting within the standard of care by performing an abortion within 24 hours of a patient requesting one, correct?
Yes. And just for clarity, by standard of care, I presume you mean the legal concept of standard of care.
I don't have a meaning other than what you understood it when you were previously asked that question.
Well, I don't know what you're talking about when I was previously asked about it. I mean, I have 3 binders of prior testimony.
Sure.
But when I'm answering the question right now, as if you're talking about the legal understanding of standard of care.
Well, you agree that in some cases, the only reason a patient in Michigan may need to wait 24 hours to get an abortion is that the law required it, right?
Sure.
You know that there are professional organizations that disagree with some of your opinions about the benefits of 24-hour waiting periods, right?
I do.
For example, you know that ACOG, the American College of Obstetricians and Gynecologists, doesn't think there should be a 24-hour waiting period, right?
No, as I testified, probably at deposition, my understanding is ACOG does not support any regulation of abortion.
But it's your belief that ACOG is biased when it comes to abortion, right?
I do believe ACOG is biased, yes.
And in fact, you believe that ACOG is attempting to control the use of language of folks who write about reproductive health to make them be less accurate and treat abortions like any other medical intervention, right?
I do believe that, yes. But specifically with respect to some documents that ACOG has put out about what they say is the language doctors must use in talking about abortion.
I want to talk about the mandatory counseling materials that MDHHS, which is the Michigan Department of Health and Human Services, puts out that you talked about a little bit with the intervening defendants. I just want to be really clear because I thought I heard you testify
that women don't have to review the DHHS materials. Is that your testimony?
My testimony is that they don't have to read every word in them. They do have to click through the online form and indicate at the end that they have reviewed that form. But there's no requirement that they, as I said, dilate on any particular part of it.
All right, you were asked about the getting your flu shot. Did the state of North Carolina require you to review information in advance of your flu shot, or was that just something that your employer, Duke University, had you do?
To my knowledge, in that case, only that was a Duke University requirement. I do not know that there was a state law requiring that.
Does Duke give free flu shots to employees?
It does, yes.
And this was part of getting the free flu shot that they offer, that you had to fill out that form and review that info, right?
That's right. It's specifically healthcare practitioners are required to have the flu shot unless they have some kind of justifiable exception.
You talked about pharmaceuticals and package inserts that accompany pharmaceuticals. Are you familiar with FDA law and regulations regarding pharmaceutical packaging and warning labels and the like?
Generally, I'm not familiar with all the details.
Do FDA rules and regulations require that when patients pick up, say, a prescription antibiotic, that they have to sign a form attesting that they received and reviewed the package insert that came with those antibiotics?
Not to my knowledge, no.
Are there FDA rules and regulations that when someone gets a prescription for the first time, they have to wait 24 hours before they can fill it and sign that form before they come back and pick it up?
I don't believe so, no.
You talked about regulations relating to breast cancer and information that should be provided to women before they make, I think, what was characterized by counsel for the intervening defendants as the irreversible decision to have a mastectomy. Do you remember that?
Objection, that was the witness's characterization, not counsel's.
Okay, well, do you remember testifying about this irreversible decision to have a mastectomy that women with breast cancer might make?
I do.
Okay. You're familiar with prostate cancer as an internal medicine doctor, would you agree?
I am.
Surgery to remove a man's prostate when he has prostate cancer is similarly an irreversible decision, isn't it?
It is.
Do men getting their prostate removed in the state of Michigan, are they required to get a state mandated information packet and a 24-hour delay before they choose to make the irreversible decision to remove their prostate?
Not to my knowledge.
As a medical ethicist, does it concern you that there are no laws in Michigan that require men undergoing an irreversible, what's been characterized as an irreversible procedure, to receive state mandated requirements, wait 24 hours, that there are for women? Does that cause you any concern as an ethicist?
It doesn't cause me great concern, but it likewise would be, I think, consistent with the norms of medical ethics if there were such a requirement.
So let's talk about these state mandated materials. And we're rounding home here, doctor, to use a bad sports analogy. I guess you're rounding third to get to home. The process of obtaining informed consent varies depending on the type of treatment a patient is getting, correct?
Frequently so, yes.
Informed consent also varies depending on the patient, right?
To some extent it does.
There is a tailoring of information to each patient's circumstances that is necessary for a provider to fulfill her obligations under the principles of informed consent, right?
Yes, there is a tailoring, but it is also the case that there's often disclosure of the same information to everyone considering a procedure.
And that
Before
same
such tailoring.
information, I'm sorry, I didn't mean to interrupt you, doctor.
Before such tailoring.
Okay. And you've referred to that as like a minimum threshold of information that folks have to get, fair to say?
Well, so ethically speaking, there is a minimal threshold that folks should get. Specifying exactly what that is can be difficult in different cases, but there is a threshold. And that's kind of what the legal requirement is focused on. Whether a particular handout includes all the information for that threshold is just, it's an open, it depends on the case, and I'd have to look at the handout to be able to judge that and have to know enough clinically to judge that.
Right. And to be clear, in this case, you're not offering the opinion that the state mandated DHHS packet of information on abortion, which has been entered as Exhibit 4, is an exact match for the minimum threshold of information that every woman seeking an abortion must receive, are you?
No, I'm just saying it appears consistent with an attempt to meet that threshold.
You don't know if the minimum threshold of information that anyone has to receive in order to provide informed consent for an abortion includes images of fetal development, right?
Right.
But you know, the state of Michigan actually requires that those images be provided as part of these statutes, right?
Right. This is frequently the case. And such documentation includes information in an attempt to make sure people have a minimum threshold, but there can be disagreements about whether every part of that is required.
And beyond this threshold of information that patients have to get, what further information is given as part of the informed consent process will vary, depending on the patient's request and the physician's judgment about which things the patient might be interested in knowing, right?
That's right.
And it's reasonable and customary in medical ethics and clinical practice for physicians to vary how much detail they give to patients based on the physician's interaction with the patient and what the patient wants to hear, right?
That's right. As part of that tailoring process, yes.
And if it wasn't for the state's legal requirements related to abortion in this case, it would be a violation of the standard of care and inconsistent with informed consent for a provider to provide information to a patient that the provider believes is irrelevant, right?
So it's important for me to be clear about this. The provider, from his or her judgment, must provide information they believe is relevant to a reasonable person. And providers also, as I say, is characteristic across medicine, are required by their institutions or their states or the federal government to include information, which may include things that they do not think are relevant. So yes, outside a requirement from some duly constituted authority, which we all practice under, to provide such information, then I would presume the physician would not provide it if they don't think it's relevant.
And in fact, more than just presuming they wouldn't provide it, absent a legal or organizational requirement, it would be a violation of the standard of care for a provider to give a patient information that the provider knows is irrelevant, right?
So if the provider knows that this would be irrelevant to any reasonable person, then they should not give that information unless a duly constituted authority has required it of them.
If there was no state requirement in Michigan for the uniform disclosure of information about abortion, and a doctor had good reason to believe that a fetus would not survive labor and delivery, it would be reasonable in your view to not give parenting information to that patient, right?
Yes, I agree.
You know, though, that because of the statute here in this case, a woman carrying a non-viable fetus still has to get parenting information, right?
She has to get it in the form of a packet of information that includes information that would be relevant to any reasonable person. It's not specified just to her case.
Right. She has to get it and she has to sign something stating that she's received and reviewed it, right?
Right. Just to clarify, she doesn't have to get it from her physician.
Good point. You're right. Thank you, doctor. With regards to the materials that the state mandates women receiving abortion receive, sorry for the double there, you believe that there may be some imaginable way that the statutes regarding informed consent here in Michigan could be improved, right?
Sure, I would imagine there's always room for improvement.
Providing additional information that's not relevant to a patient's procedure can undermine the patient's ability to give informed consent, correct?
It can, insofar as such information is not relevant. Yeah, it can get in the way of their understanding.
Providing patients with incorrect information is not good medicine, is it?
It is not.
Physicians are obligated to tell the truth and not give patients information that the physician knows isn't accurate, right?
That's correct. With the qualifier that they can give people, as they often have to do, information from some authoritative institution or body above them that they're required to give. But if they disagree with some of that information, I think they have an ethical obligation to say so to patients.
Information presented during informed consent should be presented accurately and sensitively, correct?
Yes, insofar as possible.
And you know that ACOG disagrees also with your opinions about the mandatory counseling requirements and how they benefit patients and is actually opposed to state mandated informed consent processes, correct?
I am aware of that, yes.
Thank you, Dr. Curlin. I appreciate your patience. I know this is a bit of a weird juxtaposition, but thank you for working with me and lugging those binders around. I don't have any more questions for you right now.
Thank you.
Thank you. Any questions from any of the remaining defendants? Redirect?
Doctor, you're a few paces from home plate. Did you allow any of your personal views on abortion to bias any of your opinions in this case?
No.
Same question as it relates to your religious faith?
No, I did not.
Thank you for your time, doctor.
Cross on that.
No, thanks so much, Dr. Curlin.
Thank you,
Thank
Dr.
you.
Cooper. You are excused. Are there any other witnesses?
Your Honor, at this time, intervening defendant rests.
Okay. Any rebuttal witnesses?
Happy to say no, Your Honor.
Thank you. Then that concludes the close of proofs. Are there any other issues that we need to discuss before we talk about the, since we will not be doing closing arguments, the requirements that I'll have for the findings of fact and conclusions of law?
I think
That was going to be my question, Your Honor.
that was why I stood up.
Okay, so seeing as there are no other remaining issues, I'm going to have, in lieu of doing closing arguments to the court, I'm going to have the parties submit findings of fact and conclusions of law. I would like to set a deadline of 2 weeks to do that, which brings us to March 6th. Is there any objection to that?
Your Honor, my only request would be, we don't yet have final transcripts. Could we have 2 weeks from receipt of the last final transcript so that we can appropriately cite? Starting now, we may end up with some version control. Would that be acceptable?
Yes, that would be acceptable.
Your Honor, I would ask for the same time to start, but I would ask for 28 days.
I will split it and give you 21 days from the date that the final transcripts are produced.
Thank you. The only thing I wanted to put on the record, Your Honor, we obviously, most of us, except for Ms. Tillman, have been guests in your courtroom. The experience of being in your courthouse has been absolutely delightful. The folks who work here, from Ms. Tchaikovsky to Vince, have really gone above and beyond to be gracious to us as visitors. And we appreciate all that they have done, staying late, taking care of garbage for us. They really have done everything to make this as smooth as possible. And I just wanted to make sure to thank them on the record, because the whole staff's efforts should not be overlooked. We appreciate everything that they all did.
Objection, we wanted to say that first.
I
And
agree.
we'd like to thank the opposing counsel for all their courtesies along the way.
I agree. Thank you, Vince. Thank you, Ms. Steenberg, for your services. I think that concludes our trial. Thank you. We stand adjourned.
Here,